Good morning, everyone. Did not mean to be sharing that just quite yet. Just meant to be sharing myself. It's been that kind of day already. So, I am Alternate Juror. Welcome to my channel. I hope you all had a great weekend and happy Monday. I see Gabrielle. Good morning. And good morning, Stormy. Alrighty, I think I'm ready. Our power went out. Our power goes out all the time because I live in the country, and it reset everything. So everything was off. So I was been scrambling, but I'm ready. I think I'm ready. So today we are going to do closing arguments on day 5. The prosecution rest, the defense rest. They don't put on anything. And then there's the argument for directed verdict, which you've probably heard me say a ton, is like seeing a unicorn. Just doesn't happen. I've seen it happen once, and I thought the lawyer that I was watching on stream was going to fall out of his chair because he's never seen it either. So that's all going to get denied. And I was going to go through it all, but we've got to get this finished today. I thought that jury selection for the Adam Montgomery trial was Wednesday. No, it's tomorrow. So we got to be ready to go Wednesday. I'm hoping they don't start until Wednesday. I'm hoping they just seat the jury tomorrow, and then we get to start Wednesday morning. That's my hope. So that's where we're at. So today we're going to do closing arguments, and the prosecution does something I have not ever seen. Generally the prosecutors, they go first. The state goes first in closing arguments, and then the defense goes, and then they give their rebuttal. Well, there's 2 defendants here, so I wasn't sure exactly how that was going to work. So I was curious what happened, and when I was trying to get timestamps, the prosecutors just don't go first. They just go second. So I've never seen that before, because they generally want to lay out their case, and then they want to give the rebuttal after the defense lays out their reason. So that's interesting for me. Maybe you guys have seen it before, but I haven't. No problem, Stormy. That Friday's show, I had so much fun. It was a blast. So you were here, thanks for hanging out. You hung out all day, and you guys, I just had a blast. So I hope you guys all enjoyed it as well. It was kind of nice to just kind of have a little bit of fun because of the heaviness of that was this case. So I've got this ready to go, and I think there's probably a couple things that the judge, take care of. Oh, and by the way, we will not listen to jury instructions if you're all okay with that, because those are boring, right? So we'll avoid jury instructions too. We'll just kind of get through this day. I still think it's going to take quite a while. Thank you, Gabrielle. Yeah, I had such a good time. Just laughed and had fun, and you guys were great. I thought about that all weekend, and I ran out of time. I had a busy weekend, and I was going to try to find a new background for today that had what's that called? A spittoon or whatever it's called. I don't figure I could find one, because that's probably not politically correct or whatever. But I was going to, but I just ran out of time, and I didn't have a chance to do that. But that was my goal, because I figured you guys would enjoy that. So my apologies for not having the time to do so. But we have Adam Montgomery coming up. He's probably going to give us something that we can use. All right, let me share my screen again, and let's get going. Oh, and as always, make sure you let me know how my sound is, especially today, because everything was off. Everything was not going where it was supposed to go. Cameras were turned off. Mics were turned. Everything was off. So please let me know if this is okay, because I didn't have time to test it after I finally figured out what was wrong.
Judge, there was a huge line out front, and I know there were a couple of people that wanted to be here, and I know that we can't. We can only do what
This is not an entertainment thing for the public. So I don't care less whether they're out there in line waiting to get in or whatever. We're about to start these closing arguments. I do not want people coming in and
We'll
out.
catch you next time, Hamilton. Thank you for letting us know,
distracting
though.
To the jurors who can't follow y'all's arguments because they're listening to the door opening or closing or turning around. It's kind of like a movie. I don't want people getting up and getting popcorn all the time and distracting me from watching the movie.
I understand. That's why I was asking if you wanted to wait just a couple of minutes for some of the people that are waiting, but if you don't, that's fine.
But that might go contrary to what I just said.
I don't know. I thought you
You
said
don't
you didn't want
know?
it during arguments. This wouldn't be during arguments. This would be before arguments. We just have a couple.
So you care more about the audience than you do about these jurors?
Judge, I was letting you know.
Anything else from anybody?
No, sir.
Okay, let's bring the jurors in.
Well. He's one of those judges that you can't tell. Is he kidding? Is he mad? This is your last chance to be looking at the ceiling, folks. I know. We're starting off strong today. We are starting off strong. But you're going to have just a little bit to look at the ceiling. You got to find that. You got to find that thing. He is already snippy.
Okay, everybody may be seated.
Dang.
As always, I'm going to ask you jurors, since our last meeting time, have any of y'all been approached by anybody, heard anything you're not supposed to hear, saw anything through media, the social media, the computer, the television, or through newsprint? Okay, everybody's answered no. We're ready now to start our closing arguments by the attorneys. The state has the right to open and conclude, and the state has chosen to waive its right to open, reserve its right to conclude. The more, y'all remember our conversation yesterday about time and the limits, it's the more expansive one that Ms. Zahn was talking about. Y'all all understand that? Okay, then Mr. Carter, you may proceed.
Thank you, Judge. Good morning. I want to thank you all for being here. This has been a journey for all of us, I know. You guys have been attentive. I've watched you. Sometimes as attorneys, we try to read the jury. And I can tell you, I would not want to play poker with any of you guys because I have no idea what you're thinking about this case. But what I do know is that you've all paid attention. I've seen you taking notes. I've seen you taking notes at important points. So on behalf of Mr. McNabb, we really appreciate you being here. An opening statement. I told you that Chris McNabb had nothing to do with the disappearance and death of his daughter, Caliyah. I told you that I would ask that you look for the who, the what, the when, the why, the how of this case so that you could tell a story of how this happened. I told you that Caliyah was fed and changed around 5:30 a.m. on the 7th, that Chris was awoken by a text around 9:30. He checked on the girls and they were fine. I told you at 10:20, Clarissa woke Chris and Cortney up and she was gone. So the investigation focused on Chris McNabb. And how do we know that? By the way they were questioned on the scene, by the way they were questioned when they went into the police department. We knew that the police were looking at the people closest to the child and they focused on Chris. So why did they focus on Chris? Well, he has face tattoos. There were physical altercations between Chris and Cortney. There was drug use by Chris and Cortney.
I don't think his tattoos had anything to
during
do
jury
with it.
selection, I asked every single one of you. There is going to be evidence of face tattoos. There is going to be evidence of physical altercations between the parties. There is going to be evidence of drug use in this case. Can you look beyond that? Can you take that for what it's worth? And can you actually base your verdict on the evidence of guilt in this case? And I told you if you did that, if you presume that Chris is innocent, if you focus on the state's case, you're going to find that you're wanting more, that there's reasonable doubt, and that I was going to ask you to find verdicts of not guilty.
Yes.
Now, our judicial
That's
system has
rude.
evolved over hundreds of years, started in England. This system provides protections for those accused of crimes. It's designed to provide a reliable system of justice and to prevent wrongful convictions. That's a double-edged sword. Provide justice for victims, but also prevent wrongful convictions. The judge is going to give you the charge of the court, and that's the law in this case. A lot of times that's very important. The way that the law affects the facts in a case can be very important. In this case, not so much. The basics are here, but there's nothing legally difficult about this case. The defendant is presumed to be innocent. The burden of proof is on the state through Ms. Zahn, Mr. Alexander, to prove guilt beyond a reasonable doubt, and the verdict has to be unanimous. The judge is going to give you a long charge on presumption of innocence, burden of doubt, and burden of proof and reasonable doubt. I just picked out a few of the phrases that I want you to remember, as I'm sure Ms. Zahn is going to do. The defendant is presumed to be innocent until proven guilty. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. There is no burden of proof whatsoever upon the defendant. A reasonable doubt is a doubt of a fair-minded, impartial juror, honestly seeking the truth. Reasonable doubt is a doubt for which a reason can be given based on the evidence, a lack of evidence, or a conflict in the evidence. If your minds are wavering, unsettled, or unsatisfied, you must acquit the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. In addition, the judge is going to charge you on grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize the conviction of the defendant. This is an 8-count indictment. Mr. McNabb is charged in count 1 with malice murder, in that he, with malice aforethought, caused the death of Caliyah McNabb, a human being, by inflicting blunt force trauma upon her head. That means that he intentionally killed Caliyah McNabb with malice aforethought. As we go through the rest of the charges, please understand those are the rest of the charges. They're not separate charges. They all revolve around the blunt force trauma to the child. But there are several ways of charging the exact same thing. Felony murder is murder, just like malice murder is. But instead of having to have the intent to kill Caliyah, Mr. McNabb only had to have the intent to commit either an aggravated battery or cruelty to children in the first degree. So in order to look at those charges, you've got to look at the underlying felony charges. In other words, felony murder means he did not intend to kill her, but he intended to do these other two things. So what are the other two things? Aggravated battery in count 5 says that he maliciously caused bodily harm to Caliyah McNabb by rendering her brain useless.
Good morning, Adair. Hope you had a great weekend.
I guess in some way you could say he didn't want to kill her, but he wanted to injure her bad enough to make her brain useless. But in effect, it's the same thing. If you do not believe Christopher McNabb committed this atrocious crime against his daughter, you will not find him guilty of felony murder or malice murder. Now, count 6, cruelty to children in the first degree, says that Mr. McNabb maliciously caused Caliyah McNabb cruel and excessive physical pain by inflicting blunt force trauma. So again, counts 1 malice murder, counts 2 and 3 felony murder, count 5 aggravated battery, and count 6 cruelty to child in the first degree. Those are all counts that involve Christopher McNabb causing blunt force trauma to Caliyah's head, killing her. Okay. The count 8, concealing the death of another, says that Mr. McNabb unlawfully concealed the death of Caliyah McNabb which hindered the discovery of whether or not said person was unlawfully killed by placing her body in a drawstring bag and placing the bag containing her body into an indentation in the woods. If you do not believe that Christopher McNabb killed his daughter, then it's reasonable to believe that you would not believe that he concealed her body either. There's no evidence that he killed her, that he did not kill her, but somehow concealed her body. The one charge that's a little bit different in this case is count 4, murder in the second degree. Basically, this says that Mr. McNabb caused the death of Caliyah, irrespective of malice, irrespective of whether he wanted to, by committing cruelty to a child in the second degree. So in order to judge count 4, you have to look at count 7, which is cruelty to a child in the second degree. And that says that Chris, with criminal negligence, caused Caliyah McNabb cruel and excessive physical pain by inflicting blunt force trauma upon said child to her head. So it's difficult to imagine a scenario, but in that count, Mr. McNabb is charged with cruelty to child in the second degree for negligently inflicting the blunt trauma to Caliyah's head. It's difficult to imagine how that would have happened other than maybe a television falling on her because he was on methamphetamine. I don't know. It's difficult for me to imagine a scenario where he negligently caused that injury, but that's what the charge is. Once again, if you do not believe that Christopher McNabb caused the death of Caliyah, then you would find him guilty on every single one of these charges. So what is the state's case? What's the state's case based on? Number one, it's based on Chris and Cortney's lifestyle. Number two, it's based on Chris searching in the woods after Caliyah was found missing. Number three, the fact that the backpack and the clothes that Caliyah were found in were Chris's. Number four, that Chris got out of the car whenever he found out that Caliyah had been found. And number five, I've lumped in what the state is going to say is guilty knowledge. In other words, he knew some things that he shouldn't have known. So I want to talk about those individually. Chris and Cortney's lifestyle included drug abuse, physical altercations, and face tattoos. We admitted that from the beginning. I talked to you about that from the beginning. We said we could look beyond that and look at the evidence in this case. So what do those
Good morning,
things
Lisa. Thank you for joining
tell
us.
you about the who, the what, the when, the where, and the how of this case? And the answer is not a lot. There's nothing about those particular facts that separate Chris McNabb as being the person who killed Caliyah. These are background facts, which we fully admitted. Chris's search of the woods after Caliyah was determined to be missing. Well, we know from Cortney that Chris was on the couch with her asleep when Clarissa woke them up. Melissa Davis came over to the trailer, and before Chris went out into the woods, Melissa Davis touched his hands. She said he was clean and dry, and that importantly, he did not carry anything away from the trailer. And what does that tell you? It tells you that Chris McNabb did kill this child. He either didn't do it in the trailer or the child was not still in the trailer when he went out into the woods, and that's important. If he would have gone out earlier and put her body out in the woods where she was found, we would expect his clothes to be wet. We would expect his shoes to be dirty. There's no evidence of that in the trailer or on Chris. So what does that all mean? Like, what does that mean to the story of who, what, when, where, and how? You've heard evidence that.
Did they determine that the shoes were his that they found out in the woods? Because then there's the shoes. And also, if somebody having face tattoos is your only defense, like that's the only reason that he was charged because he has face tattoos, having face tattoos does not make you an unaliver. That's ridiculous. And the evidence of face tattoos, is that because he's sitting there with them? He has more than he did when he was charged. So how'd that happen? Because I'm sure he was in custody. I don't know. This guy, I get it. He doesn't have much to work with, but dang, dude, do something better. Because this is not going anywhere. And Stormy, I agree. He does seem more upset than Cortney, but I think it's because he knows what he did. And the writing's on the wall or on his face. Had to. Sorry.
The backpack and clothes that Caliyah was found in were Chris's. Now, whether he is a crazed meth fiend or whether he is a cruel planning monster, under what circumstances would a person who killed this child place her in his own bag with his own clothes?
Exactly.
How did that happen? But we do know, and there's no question, that the tote carrying Chris's stuff was right beside Caliyah when the last time he saw her, or the last time that Cortney saw her at 5:30. The tote was right beside Caliyah. By 10:20 in the morning, the tote had been moved over and was sitting on the bed. So somebody had clearly done something with that tote. And we know from Chris's statement that his clothes were in that tote and his bag was probably in that tote. So what does all that mean? What does that mean to this case? We've heard evidence that Chris got out of the car whenever he heard that Caliyah had been found. We know that law enforcement focused on him from the beginning, and he knew it. We knew that Kim, Cortney's Aunt Kim, was yelling, "Chris did it," on the phone. And we know that Pam not only told Chris to get out of the car, she got out of the car, opened the door, and let him out. The state's also going to say that Chris had guilty knowledge because he went into the woods, searched the woods in that general area, and that he had placed a camo jacket in that area. Now, despite comments to the contrary, it's clear that that cut through was used. You all saw it. We all walked it. There's trash. There's stuff all along that cut through. It's a very clean, clear area. We heard also that in 2017, Henderson Mill Road did not stop over at the church. Henderson Mill went straight down to Henderson's restaurant and Henderson's grocery store. So there's every reason to believe that Chris and many other people used that cut through. And if Chris going into that area leads you to believe that he killed Caliyah, what does it mean if Caliyah wasn't even there on the 7th? How does that affect your decision as to whether Chris did this if Caliyah wasn't even there on the 7th? Again, when Chris got out of the car, he was clearly a suspect. There's ample evidence from Kim Weatherford, Pam Hamby, that Chris knew that Caliyah had been found, that she had been found dead in the woods, that Kim was yelling at Chris, that Chris did it, Chris did it, Chris did it, and Pam told him to get out of the car. Now, instead of heading in any other direction, as you've seen from the maps, Chris headed directly toward the trailer. He did get out of the car. He walked directly toward the trailer. He walked to the Chevron station. He walked in, said, "This is who I am," knowing they would call the police. When the police got there, he voluntarily laid down and was arrested. That's not guilty knowledge. In over 8 hours of statements, at one point, Chris says, "I loved her." No, he said, "I love her." And Cortney said, "What do you mean loved her? What does that mean?" And so one might say that's guilty knowledge. He knew she was dead at that time. There are a couple of things about that. Number one, you could tell he was losing hope as time went by anyway. But he immediately corrected himself. I didn't mean to say loved, I meant love. And moments earlier in his statement to Jeff Alexander, I mean, literally 10 minutes earlier, they were talking about Caliyah's hair. And he said her hair is going to turn out just like mine. That is not the statement of a man who knows his child is dead. That's a statement of a man who still has hope that she's still alive, and that when she grows up, her hair is going to be just like his. It's going to turn out just like his. So what are the weaknesses in the state's case? Number one, there's a strong, consistent timeline that shows Chris McNabb did not do this. There's a lack of any direct evidence, witnesses, scientific evidence. And then you've got this guided investigation. So with regard to the strong, consistent timeline, Chris and Cortney both saw Caliyah alive and well around 5:30 a.m. It's uncontradicted that these parties both saw her alive and well at 5:30. Chris says that he saw Caliyah alive and well at 9:30. And there's no particular reason for him to say that he got up. I mean, yes, we know that his dad texted him at 9:30, said, "Are you awake?" And he said, "Yes, I'm awake." But he does not have to say, "I got up and they were fine at that time." He doesn't have to limit the timeline, but he does, because he did. He did get up and check on Courtney, Clarissa and Caliyah, and they were fine at 9:30. Chris and Courtney both woke up around 10:20, and Caliyah was gone. Now, you've got a lot of Facebook records, you've got a lot of information to deal with, but please go through thoroughly and check that we're all correct, because we've gone through all these records. The records back up this timeline. We see activity on Chris's phone at 5:30 in the morning, 5 to 5:30 in the morning, all the way up until 5:50 in the morning. That's completely consistent with their timeline of where they were. They went to bed around 5:30. He laid on the couch, and he was off Facebook by 5:50. At 9:33, his dad called him, texted him and said, "I'm putting some money in for you for rent." Chris said, "I'm awake." Or he said, "Are you awake? I'm putting money in." Yes. We know that at about 9:42, he got on Facebook and he realized he had blocked Courtney Morris. So he just wrote back to her, "Hey, sorry, I didn't mean to block you." And he tried to call her, but she didn't answer. At that point, he went back to bed. Now, he does not remember that in his statements, but again, there are lots of things that we do that we don't necessarily remember when exactly we did it. But that call is completely consistent with the timeline that Chris was awake at 9:30, went to sleep after 9:42, after 9:45, sometime during that time. There's a lack of direct evidence in this case. This case is so circumstantial that it requires an enormous amount of speculation on your part to say Chris McNabb is guilty of this crime. And I got to remind you, this is not Las Vegas. We're not laying down odds on who did it. And you are not investigators in this case. You are not given the choice of finding out who actually killed her. Your only job is to do your duty, which is to give Chris McNabb due process. Due process means presuming that he's innocent, making the state build its case. It's not who do you think the most likely person to have done it is. It's did the state prove Chris McNabb guilty beyond a reasonable doubt?
This one's pretty straight. You're right.
Guided investigation. We know, you've seen the evidence. They focused on Chris McNabb from the very beginning. They cut corners on the crime scene investigation because they believed they had their man. Is there anybody who has any doubt about either of these? That they focused on Chris McNabb and that they cut corners? Mickey Kitchens admitted mistakes were made. I just overlooked things. There are things that I should have done. There are things that I would have liked to have done, but they weren't done. And when you hear an officer who is up here trying to justify their case, trying to justify their warrants, say, "Yeah, I was able to eliminate all other suspects." Well, that's great. I wish he would have. But then when you look closer and you say, "Well, how did you eliminate those suspects?" "Oh, I just decided they didn't do it." That's not the way to run an investigation. Was there blood? Was there any other identifying information, fingerprints, anything at the trailer, at another crime scene?
Whoops, that's not me. This cameraman. Gabby, do you need a mint? Oh, man. All I have to say is if it's not him, then who? Because she was asleep. We've pretty much, I think, kind of got that. So you've not served the invisible insane asylum person? Like, who? They already went through that there wasn't anybody missing at that time from any mental institution or whatever they were calling it. I don't know what has happened here, but oh, cameraman just wanted to give us some fun. Have to be careful because it's not like the picture will come back. The sound will just come back. Was he saying something bad? Ah, the cameraman's probably, he's like, I'm out. I can't do this. Good heavens. I didn't see this when I was getting timestamps because I wasn't looking for it to just go silent. There he is.
You guys know any
Found him.
document, you can take something out of context and make it sound good. There are places in the Bible where it says you should kill your children if they disobey you. You
Wow.
can't take things out of context. You guys have heard all 8 hours of these statements. You've taken notes. You know this case back and forward. You know everything you need to know to make a decision in this case. Nothing that she's going to say is going to be able to change the fact that the state has not proven guilt beyond a reasonable doubt. We talked about the who, what, when, where, how, and why of this case. So who killed Caliyah McNabb? Is there any real evidence Christopher McNabb killed his daughter, brutally killed his daughter?
Yes.
Did the state exclude the theory that someone other than Christopher McNabb killed Caliyah McNabb? Have they done that? Have they excluded every reasonable theory other than the fact that Chris McNabb did it?
Yes.
And looking not just at the state, not like just at Ms. Zahn, but look at the investigation. Was this investigation conducted in a manner that would convince you that Chris McNabb committed this crime beyond a reasonable doubt? What happened? How was she killed? If she was struck with a blunt object, what is that object and where is it? We don't have any idea. Was Caliyah in the bag when she was killed? Was she outside of the bag when she was killed?
At the bottom of his leg.
If you think about that, why did the killer put her in a bag? Why was it necessary to put her in a bag? If Christopher McNabb killed her at 5:30 in the morning and took her out, why would it be necessary to put her in a bag? Why couldn't he just hide her as she was? And if he was going to put her in a bag, why would he put her in his own bag? He's about the only person who knew. He and Cortney are the only people who knew that was his bag. When was Caliyah killed? Do you think Cortney Bell is lying when she said that Caliyah was fine at 5:30 in the morning? Does anybody believe that Cortney Bell was lying about that? Does anybody believe Chris McNabb was lying when he said Caliyah was fine at 9:30? And if you don't believe that, if you don't believe that Chris got up, checked on the girls, texted with his dad, and sent a Facebook message at 9:30, and they were fine, why don't you believe that? What is it about this case that makes you not believe that Caliyah was fine at 9:30? If Mr. McNabb had done this between 5:30 and 10:30, a meth person who uses meth, wouldn't he be freaking out? Wouldn't he be worried? Wouldn't he be trying to cover his tracks? No, instead, he's asleep on the couch with Cortney. Do you, sitting here today, honestly have any idea when Caliyah was killed? Where was she killed? Did Chris completely lose his mind and kill Caliyah in the back bedroom of the trailer? If so, why didn't Clarissa wake up? Why didn't Cortney wake up?
I think Clarissa might have woken up.
If not, if he didn't do it in the trailer, he had to have planned this. He had to have said, I'm tired of this child. I'm going to go kill her. So he took her out somewhere else and killed her. If he did that, why did he put her in his own clothes? Why did he place her in an area very close to an area?
So I'm thinking if they were doing illegal substances, I don't want to get in trouble here, but that keep you up for days, right? And if he's coming down off of that at that time, if you're up for days just off as a regular person that's not doing bad things to your body, you start seeing things. You things that aren't there. But if I've never done that drug, so or drugs, not just that one, but is it possible he saw something and And it was her, but she just he didn't know it. Is it possible she started crying and he couldn't stop her? There's so many things that could have been going on at that time that explain that, yeah, he did this. And I kind of think Clarissa woke up. I think that's why if you listen to Courtney's 911 call, she says, I was over there because it didn't make sense to me. But she said, I was over there loving on Clarissa, like trying to calm her down. Well, why would she have to calm her down? She's not going to understand. She's 2. She's not going to understand that a baby's missing and what that possibly means. So I think she probably saw it or heard it or something. I hope she doesn't remember it. But yeah, and this prosecutor, man, that pause on her right now is like, hold my beer, because I'm coming after you when you're done with this, Mr. Attorney. I'm gonna make you regret all the words you're saying right now.
That people already know he hides things. People already know he hides that camo bag in that area. We've all seen where the camo bag was. We've seen where the body was. Why would he do that? If he had time to plan, if he had time to take her out of the trailer before he killed her, why would he do that? None of these scenarios make any sense at all. And why was Caliyah killed? The state's going to tell you, we don't have to prove any motive at all. You see a lot of crime shows, a lot of courtroom dramas. People, what's the motive in the case? In Georgia, it's true. The judge is going to tell you the state doesn't have to prove a motive. But isn't that something you want to know when you're making your decision? There were no pre-existing injuries, no evidence whatsoever that Chris ever hurt any child. Caliyah, Clarissa, any child. If this was just a sudden act of passion, how did it happen without any witnesses, without any physical evidence, or any other indication that Christopher McNabb killed this child? If this is just a spur of the moment act of passion, why is there no evidence? We know that Tim Bell, Megan Sorrells, any number of people could have and did take care of Caliyah when Chris and Cortney were struggling. Chris knew that. Chris knew that his dad would take care of Caliyah. He knew that Tim would take care of Caliyah. He actually, on the day before she died, on October 6th, we have evidence that he fought for his children, that he fought for them to come back from Tim Bell's house because he wanted to be with his children. He wanted to be with Caliyah. We know that. So why 12 hours later did he decide that he was going to kill her? Now, the defense has no burden whatsoever. The judge is going to tell you can't hold that you can't hold the fact that Mr. McNabb didn't testify against us. You can't hold the fact that we didn't call any witnesses against us. The defense in this case is that Christopher McNabb did not do this and that the state cannot and did not prove that he was guilty. But if I had to make some guesses, is it not possible and even probable that somebody grabbed Caliyah while Chris and Cortney were sleeping? Clarissa's sleeping right here. There's a tote right beside her. Somebody grabbed that tote, apparently grabbed some stuff off the top of it. The stuff on the top of it was underwear, clothes from Chris, and Chris's bag. Why they grabbed that, I don't know. Again, we have no burden. But what if they did grab that and they took Caliyah? At some point on October 7th or 8th, Caliyah died, whether it was by this person's hand, whether it was an accident. We don't know.
An accident.
And then what if once this came on the news, this became a very public case, what if the kidnapper waited until the initial search ended, drove down Henderson Mill Road and deposited Caliyah in a convenient spot right beside off the road? Now, a lot of people are wondering why I asked that you be able to go out to the crime scene. I wanted to show you that if you're coming from the trailer and you're heading to the place where the body is found, you are faced with a long line of woods. So to get to that spot, you're either going to have to go through ride, woods, everything straight ahead, or you can go around to the right. I know you guys recall, we were just there last week. You can go around to the right. There's still woods blocking your way in that direction. If you were to back up and get again to the wood line and go around the side where that other person's property is, if you go around that way, you're still looking at woods. The only way to really logically go from the trailer park to that area where the body was found is exactly the way we went. You would go straight through the cut through because it's easiest. You would walk over to the little trash can, you would see the indentation, you would go over there and you would do your best to put her into the log and you try to cover it up. That is less easily done from the trailer park than it is from somebody driving down Henderson Mill Road, knowing the trailer park is on the other side of the wood, looking out from their car, seeing there's a place to put the body, to stash the body, and doing it very quickly. I'm not saying that happened, but it's very, very logical. It's very, very reasonable to believe somebody did that. And we know that Chris McNabb did not do that. From the time they called the police till the time he jumped out of the car the next day, he was with somebody. He was with Cortney. He was with Craig Weatherford. He was with Jeff Alexander. So we know Chris didn't do that. So who did? This is the state's theory, as far as I can tell, based on the evidence right now. Chris McNabb brutally killed Caliyah 3 feet from Calissa while Cortney was sleeping in the other room. Chris then decided to use his own bag to put Caliyah in. He decided to use his own clothes to cover her up. And then he decided to hide her about 100 feet from a place where he'd already hidden other things. And Cortney and Shane Kidd knew that he had hidden the camo bag. So he did those things. He got back to the trailer in time before Cortney woke up. By the time she woke up, he was already laying on the couch with her, pretending to be asleep or asleep. So what did he do? He helped look for her first, but then he immediately ran out within a few feet of where the body was found. And when the police got there and he came back down Highway 36, they said, "Where did you go?" He goes, "I went right over there." He pointed right at where the child was. These things don't make any sense to a person with guilty knowledge. This does not make sense for a person who had already stashed her body under that log. He pointed exactly to the log. And Ms. Long is going to say, well, you know, he knew where she was. That's why he went out that way. It doesn't make any sense. Now, why should you find Chris McNabb not guilty? Judge is going to tell you that reasonable doubt can be based on evidence, can be based on conflicts in the evidence, and it can be based on lack of evidence. And that's what I'm talking about in this case. There's a complete lack of evidence that Chris McNabb committed this offense. The judge is going to tell you that if you have one reason to believe the defendant is not guilty, your verdict should not be not guilty. Let me say that again. If you find one reason to believe the defendant is not guilty, your verdict should be not guilty. I was brainstorming and I just was thinking of what are some of the reasons. Let me give you a few reasons. And if you believe any of these, then I believe your verdict should be not guilty. Chris and Cortney's timeline of events has been consistent from the time they realized Caliyah was missing and called 911 until today, right here today. All right? They said they put Clarissa and Caliyah to bed around midnight. Caliyah was up several times. Chris and Cortney both helped feed, change, and comfort Caliyah around 5 a.m. Chris woke up briefly around 9:30 a.m. and checked on the girls. Clarissa woke Chris and Cortney up around 10:20. This is our timeline. So how do we know that? Cortney's 911 call. From the very beginning, she has told this story that they were asleep. They fell asleep. When they woke up, Caliyah was gone. We saw two body cams of the initial police getting there. They told the exact same story. They said, we were asleep. We woke up. She was gone. There were 6 recorded statements between Chris and Cortney, 3 each. In each of those statements, they held true to those timelines. And as I've said, all the Facebook records, all the messages back that up. Chris was on his Facebook until 5:51 a.m. He went to sleep. At 9:33, his dad called him. He told his dad he was awake. He checked on the girls. He messaged Courtney Morris, and he went back to sleep. At 10:20, Caliyah woke them up. They were both on the couch, and we know what happened from there. Courtney's 911 call. My daughter woke me up on the couch, and my 2-week-old is not in her sleeper. I have looked everywhere in the house, so I do not know any other possibility. I fell asleep on the couch. Me and him, meaning Chris, woke up together. She woke us up together. Now, Shane Kidd tells you that between 7:30 and 8:30, Chris was calling him wigged out that Caliyah was missing. First of all, Shane Kidd is a convicted felon, and he's been convicted of lying to the police on 3 different occasions. Then he came in here and he lied about his probation warrant. He said he had no idea that he had a probation warrant, and that the DA did nothing to help him with that. But Bo Alexander got up and he told you Shane Kidd would not come into their office because he had a probation warrant. He did not want to get arrested. So Bo made a call to a narcotics officer in Jasper County who was able to get that probation warrant lifted. 2 days later, Shane Kidd came into the office. Shane Kidd is absolutely unbelievable in this case. And the fact is, we've got all these records. We've got every account from all these people. There's zero evidence that Chris McNabb contacted Shane Kidd between 7:30 and 9:30 on October 7th. There's absolutely no evidence that happened. If you base a guilty verdict on Shane Kidd's testimony, it would be a huge mistake. Again, there is no evidence whatsoever of any prior abuse by Chris against Clarissa, Caliyah, or any other child.
Just Courtney.
All the dogs, Elvis, Alpha dogs, they all tracked toward that easement, but none of them found Caliyah. You heard how many trained law enforcement officers are out doing grids around that property on October 7th. We know that the state's case is Caliyah was right there that whole time. She was within feet of those searches the whole time. But a civilian, Tara Robinson, she walked from the church in the opposite direction. Then she came up Henderson Mill Road with a search party. And what did she say? She said, I saw that log and it was just arranged oddly. I saw some twigs on top of it, looked like they were arranged, and then they were covered with leaves. I immediately saw something wasn't right. So I grabbed a twig and I looked around in there and I realized there was a bag in there. It was not, on October 8th, it was not difficult to find Caliyah McNabb's body. Tara Robinson, an untrained civilian, thought that doesn't look right. And she checked and she found the body. Caliyah McNabb was not under that log on the morning of October 7th when the police looked. And if she wasn't, Chris McNabb is not guilty of this offense. So did the dogs track Chris's scent? We know that they were tracking Caliyah's sleeper, which Chris was the last person to be with her. I don't know. Jeff Alexander said they just went in that direction because that's where Chris said he went. But again, Chris told them exactly where he went in the woods looking for Caliyah, and her body just happens to be found the next day in that spot. We know where Chris was from the time the police arrived until her body was found. If Caliyah McNabb's body was not under that log on October 7th, Chris McNabb is not guilty of this offense. Do you believe the state has proven to you beyond a reasonable doubt that Caliyah McNabb was under that log? And certainly the answer is no.
Did you see that look she just gave him?
The autopsy shows that
Daggers.
the death could have occurred in several different ways. Could have been an accident. She said maybe a television falling over on top of her. It could have been several blows with a blunt object. And we know from the autopsy that she had no pre-existing injury. neither Chris nor anybody else had abused that child prior to the night of October 7th, the morning of October 7th. We don't know if Caliyah was killed in that bag or she's put in the bag after she was killed. And we know that there were leaves inside the bag based on the autopsy, based on the unpacking on the autopsy. What does that mean? I suppose the state would say that Chris killed Caliyah in the bedroom and then took her body and his bag out and wrapped them in the woods later. Or I guess theoretically they could say that he took Caliyah, his bag and his clothes, and he took them all out to the woods, killed her there. I don't know what the state's going to say, but I can promise you the state doesn't know. And I know that you don't know. And that's the important thing in this case. Friday night, October 7th, about 8:30 p.m., Caliyah McNabb was sleeping like a baby, and Chris McNabb seemed like a proud father. So that's 8:30 p.m. It's actually October 7th, or it's actually October 6th. Friday, October 6th. Craig Weatherford was at the trailer. At 8:30 p.m., he said, Caliyah was sleeping like a baby, and Chris McNabb seemed like a proud father. So what happened between 8:30, 9:30, 10:30, 11:30, 12:30, 1:30, 2:30, 3:30, 4:30, 5:30, 6:30? What happened in those few hours to turn Chris into a cold-blooded, brutal child murderer? And not just any child, but his child. What happened in those few hours? The layout of the trailer shows how someone could have gotten in the back door without alerting Chris and Cortney. If you recall the layout of the trailer, what they call the front door is kind of on the back side of the trailer, but the front door comes directly into the living room. From the initial dash cams, we saw that there was a sheet hanging up right there beside the couch. That was basically just kind of a doorway, a type of doorway. If you go down that hall, then that's the back door. Chris McNabb told you in his statements that that back door happened to be unlocked. They said they tried to lock the doors, but that door happened to be unlocked that morning when he came out. So we know that it's possible that someone could have snuck in that back door, grabbed Caliyah for whatever reason.
But people just don't do that.
Melissa Davis was the first person that Cortney got in touch with, and she ran down to the trailer once they determined that Caliyah was missing. Melissa Davis helped search for Caliyah. Chris McNabb was still there at the trailer when she got there. She says she grabbed him by the hands and said, "Be strong." She said his hands were clean. He was upset, but there was nothing about him that led her to believe that he was dirty, that he was wet. She said he just seemed normal. She watched him leave from there and said there was nothing in his hands. So we know that Chris McNabb did not stash Caliyah's body somewhere in the trailer or under the trailer or around the trailer, and then when Melissa Davis got there, take Caliyah out and hide her. We've shown that's not a possibility. And again, none of us at this point know what the state's theory is going to be, but just remember that's not going to work for the state, because we know Chris was not carrying anything in the woods when he left at 10:30, 10:40 on October 7th. And again, we know that Chris didn't place the body in its final resting place between the 7th and the 8th. We know where he was at all times. Once he came back to the trailer, he was with law enforcement. He went over to the law enforcement center. He came back home, and he was with Chris and he was with Cortney and Craig Weatherford constantly until he jumped out of the car once Caliyah was found. Even Investigator Alexander said, "We know where you've been." When he said, Chris McNabb told Investigator Alexander, "I don't think her body was there yesterday. I think somebody put it there. And I couldn't have done it because I've been with Cortney and I've been with other people this whole time." And Investigator Alexander said, "Yeah, we know where you've been." So again, we know Chris did not move the body after October 7th, after the police were called. In her however many hours of statements, Cortney told law enforcement everything bad she knew about Chris McNabb. And I guess that's one of the pitfalls of trying this case together. The judges told you can't use any of that information that Cortney provided against Chris McNabb because this is a dual trial. So you're going to have to try to get some of those things out of your mind. But I do want you to realize that she said everything bad that she's ever known about Chris McNabb in these statements, and she still knows nothing about whether or not he killed Caliyah. In fact, she does not have, she didn't wake up. She believes that he was on the couch with her and that they woke up together. Remember, too, that even in his third statement, which was December, 2 months after this happened, Chris begged investigator Alexander to keep looking for suspects. Even months after he was charged, he was saying, I know you think I did this. I didn't. Please don't stop looking. Please don't give up hope that there is somebody else out there who did this. Now, the presumption of innocence and the requirement that the state prove guilt beyond a reasonable doubt, it applies in all cases, not just shoplifting cases, not just small cases. It's amazing when we have a smaller case, we have a misdemeanor shoplifting case, it's easy to say, okay, defendant's not guilty, let's make him prove it. In a case like this, you guys want to solve this. You want to know what happened. But that's not what this is about. This is not about solving a crime. This is a very limited inquiry. The question asked of you is not who did this or, who do you think is most likely to have done this? The question, the very, very narrow question for you is, did Christopher McNabb brutally kill his child on the morning of October 7th? Not just did he do it, did the state prove he did it? There's so many layers there that given the evidence that you have, it's impossible to convict. And that puts you in a bad position. I know that you probably came in here wanting to know what happened, or maybe thinking, well, we're going to, hopefully we can find justice for baby Caliyah, but that's not your job. Your job is the very narrow issue. Did the state prove its case beyond a reasonable doubt? If you were charged with murder and were on trial for your life, would you want these kind of things done so that the jury would know for sure, wouldn't you? Lead crime scene investigator Mickey Kitchens. Yes. Mistakes were made. There are things I should have done. There are things I could have done. And if I would have done those things, maybe we would know for sure that Chris McNabb did this. Or maybe we would know that Chris McNabb did not do this. Those things were not done. There are things sitting in the GBI crime lab right now that we don't know what the results are. Chris's clothes were never tested. And whether it be the day before or that day, that's something important you'd want to know. Do you not want to know if there was blood from Caliyah on Chris's clothes? Would that help you in your decision? Would that solidify your decision as to whether he's guilty or not guilty? Absolutely it would. You cannot hold it against me that didn't happen. That is all on Jeff Alexander. That is all on Layla Zahn to prove to you. It's not there. I investigated Shane Kidd and all the other potential suspects in this case, and I was able to eliminate all of them. That sounds great in theory. Again, that's awesome. He eliminated every single suspect. So what did Shane Kidd tell you when you asked him about it? Oh, I didn't talk to him. Well, how'd you eliminate him? I just decided he didn't do it. Sitting here, right here today, are you not aware that Matt Lester was in jail on October 7th, 2017? I am not aware of that. Wow. This is one of the main people that hated Chris. He just got into a fight with. Chris told him on October 7th, if there's anybody that might have done this, it's Matt Lester. He never spoke to Matt Lester. He never did anything to eliminate Matt Lester as a suspect. I did. As soon as Chris told me, I looked it up. I knew he was in jail. The lead investigator in this case, sitting in trial, did not know that one of the other suspects was excluded because he was in jail on October 7th. When I first got this case, this is what I saw first, and it scared me to death. We went to sleep. When we woke up, she was gone. That is every parent's nightmare. I tried a case several years ago, early 2000s or whatever. The victim in that case was 2 years old. She was run over by a car. I had a 2-year-old at the time. And we try to act tough out here, and we try to act like things don't bother us or whatever. But for years after I tried that case, I would get up at 2 o'clock in the morning. I don't know why, but at 2 o'clock in the morning, I would get up every morning, and I would go and just listen to see if my baby was breathing. This is horrible. Caliyah didn't deserve to die. She was brutally murdered by someone. Cortney Bell lost her baby girl. Chris McNabb lost his baby girl. If he did it, I mean, like Jeff Alexander said, he should be put under the jail. But there's just not any evidence. Probably the worst thing that could happen to Chris is that he loses his child, and then he goes to prison for killing his child when he didn't do it. We went to sleep. When we woke up, she was gone. One reason equals reasonable doubt. If you find one reason to believe the defendant is not guilty, your verdict should be not guilty. This is the end of the evidence. This is the end of my time with you. I'm begging you to look at the evidence, to presume that Chris McNabb is innocent, to ask yourselves if the state proved he was guilty beyond a reasonable doubt, to look at all this evidence, to look at everything that was presented to you and everything that was not presented to you. And please, please come back with the only true and just verdicts, which are going to be not guilty on all charges. Thank you.
All right, so I know that was a struggle because some of the things he's saying are just so far-fetched. But remember, Elvis, the dog, he didn't like cadavers. So he would not have found her if she was there that day. I don't know. They just said he didn't search for cadavers because he didn't like them. So I don't know if he just ignored them or if he would have sensed, smelled her body there, for trying to put it nicely, if he just wouldn't have gone there, just turned around, not alerted. They didn't say. But also, dogs are not 100% all the time. I've seen other trials too where they've missed it. They missed it, the body. So they just aren't 100% all the time. The medical examiner also, said that this was a head wound, but it wasn't like an open wound. So it's not like it was going to be bloody. So even if he did it in the house or not in the house, it's not like there was going to be a trail of blood there. So, I mean, it's kind of, they should have had his clothes tested. Why? I don't know why they didn't, because that could probably give us something. Maybe. I don't know. The one ingredient he left out of his whole thing is meth. And I again, don't know. And Stormy, I don't know the answer to that. She's tiny. She's wrapped up. She's buried. I have no idea. Now, I will also say this. Everyone is entitled to a defense. They have a right to it, whether we like it, whether we don't. He had to come up with something. I don't know what anything better he could have come up with. So he had to do something. He did his job. That's all I can say. What's throwing me off here is Chris McNabb's emotions. I keep wanting to tell myself it's because you know what now you're clear-headed. The drugs are gone. And you know what you did, and this is horrible. And then the other part of me, it's like, well, maybe did he do it? I would convict him if I was sitting on that jury because I can't come up with any other logical explanation of what happened. People just don't come in and take newborn babies, unalive them in a horrible way, and drop them in the woods. They just don't do that. That doesn't make sense. So, I don't know. Again, he did what he had to do. So I won't fault him for that. The investigator over there looked like he was about to grab him and take him out back and like beat him up. Like, stop talking. Don't talk about our investigation. So I'm not sure if the state will go now or if uh, Courtney's attorney will go and then she'll go after. And to me, it would make sense if she went now and then Courtney, but I don't know. We'll see because this is new to me. I've not seen this with two defendants.
Mr. Frost?
Nope. Courtney's attorney's going. Hand off for 20 eyes chewing gum. No, that's a no-no.
Counsel, ladies and gentlemen of the jury, Anthony. Good morning. I want to thank you for your service here on behalf of Ms. Bell and myself and everybody. As I said in my opening, you are a critical element, if not the most critical element in our criminal justice system. And without you, it simply doesn't work. I want to thank you also for clearly being engaged throughout this trial. It was evident. And that's all we can ever ask for as trial lawyers. So I appreciate that, as does my client. In opening,
Has ticks.
I just
I'm
want
not
to
sure.
revisit that briefly. It was short, fairly short. I asked you to do a few things. I remember my client
I
was
tend to agree.
shrouded with the presumption of innocence, which she still is. And I hope that you will find that she remains that way after your deliberations. I also asked you if you would remember reasonable doubt, and we'll go over that in just a minute. And I think Mr. Carter kind of parsed out some of the important pieces of that, and I'll go over them again because they are very much worth mentioning. The state does have the burden on all of this, and I too feel that they have not met that burden, and I'll give you many reasons why. The most important thing that I want to go over and that I asked you to do was keep a notepad, and I hope you did it. A column, divide it down the middle, and I suspect that the side for the state probably has a great many things that you put down. If there is on the other side, the defense side, questions, or I don't want to say points because that's not what this is about. But if there are things that you felt were in favor of the defense, if there is only one thing, I don't care if there's 500 million on the left side for the state. If you have one, and that one question leaves any of your minds wavering, unsettled, wanting more, that's reasonable doubt. and you must acquit in that occasion. And I hope that the same diligence that you gave out here receiving the evidence, you will take back there into your deliberations. I hope that you will discuss with your fellow jurors, hey, I have this thought. I did what Mr. Frost asked, and I have this comment written down. What do y'all think about it? Can we engage in this? And you all have a charge, and by law should do that. You're not to surrender any of your opinions for congeniality or speed or efficiency. This is their lives. You must deliberate every issue, and all of you, not some of you, must be convinced that every single element has facts that you can say that has been proved beyond a reasonable doubt. Mr. Carter went over a lot of things that I'll probably maybe touch on a little bit because, as you know, they were very different cases, and I'll thoroughly explain that in a moment. But as far as his argument goes, I could not agree more. There are some really serious holes in the state's case, and they will try to just pack this together and say, he did it, she set the table, boom, done, call it a day, let's go home. It's just not that simple, folks. We don't even know, and it's certainly not an open and shut case that Mr. McNabb even did it. We have all kinds of questions about that, and I'm not going to get into this. Is obviously I represent Ms. Bell. It's between Ms. Zahn and Mr. Carter and you as to Mr. McNabb's fate. But I will say this. There are some serious holes in the investigation. There are some serious questions that I'm left with. Among them are, well, who did it? When was it done? How was it done? These are things, this is not my, just making this up. These are facts that we don't know. No one can say when this happened. We have no murder weapon. And Mr. Carter's right. We don't have a motive. What on earth would ever possess anybody, whether it be Mr. McNabb, Mr. Kidd, Mr. whoever, to do what was done to that baby? I think that's the one thing I said in opening that every single one of us in this room would agree. This is one of the most heinous crimes I've ever been a part of, seen, heard about. But what would possess anyone to do that? They have offered nothing, no reasoning whatsoever that he's been a domestic violence abuser. Well, there are many people who do that. They don't often go off and do what was done to baby Caliyah, and I'm just going to leave it at that because I don't think it's necessary to keep reminding everybody of what did happen. It was horrible enough. But where did it happen? It's not likely it took place in the trailer. And if you do believe Mr. McNabb is the one who did it, he says that he went outside at some point. So did it happen inside, outside? We don't know these things. And it's not just one thing we don't know. It's many things. And then we get to the investigation. And Mickey Kitchens, I applaud him. He did not do what I get so frustrated with when I'm trying to get an answer that is patently clear and the witness will not answer it. He said to Mr. Carter, you know what? I made a mistake. Good for him. Because there's not a person in this room, not one, who has not made mistakes. And if there is somebody who's thinking to themselves, I've never made a mistake, they're living and swimming in a river in Egypt. Denial. Because we've all made them. And we know it. Some are horrifying. Some might be, well, I accidentally parked in a parking space I shouldn't have parked in. The point is, he was man enough and a professional enough, more importantly, to say he should have done this. When Mr. Carter said, what if you were on trial? Wouldn't you want this done? You bet I would. You bet I would. So Mr. Carter made some incredibly good points. As far as one thing I do disagree with him is he said, we don't know what the state's going to argue. I know exactly what they're going to argue. They're going to argue he did it, and she set the table to let it happen. That's as simple as it gets, because that's a nice little package. That's like when you go to Kroger and you buy boneless, skinless chicken breasts. You don't have to go out and get your hands dirty, cut the head off the chicken, and pluck its feathers and rip it apart, gut it, and do it. You just go in there and you buy a nice little sanitized plastic wrap dinner. It's easy. It's so easy, folks. But it's not, because that's not how we work. We don't just rush to judgment. And I'm sorry to borrow that phrase, but it's been used because it's true. We complete our investigation. We run down every lead. The theory is it is better for one guilty person to go free. 10 guilty people to go free than one innocent person ever spend a day in prison. That's our theory. That's what makes us who we are in this country. And that is all you need to concern yourselves with. If the state didn't prove it, it isn't your fault. So you don't need to say, God, you know what? Dang, I don't feel good about this, but we got to rectify the situation somehow. So let's err on the side of caution. That would be not only violating your moral obligation, but it would be violating the charges that you are going to get from the court. And I know y'all don't want to do that. So, where to go with this? So much. Let's talk a little bit about reasonable doubt. And I'll be very brief about this because Mr. Carter did go over it. But reasonable doubt is a doubt for which a reason can be given arising from consideration of the evidence, a lack of the evidence, or a conflict in the evidence. If, considering the facts and circumstances of this case, your minds are wavering, unsettled, unsatisfied, that is a doubt of the law, and you must acquit. Hope that you will take those words to heart because they are critical. If you are sitting there thinking to yourself, I don't know, that's it right there. Stop. You're done. That's it. You must acquit. It's important that we get into this legal part of it. You are going to hear it, but you're going to hear it in a 35, 40-minute recitation from the court, all bundled all together. And so it's important that you know these things and that I spell them out to you. Not that I think that you're not smart enough to do that, but it's hard when you've got 40 minutes of just reading to catch everything. Now, I don't know what the response from the state will be. That I don't know. I know that they're probably behind me feverishly writing, both of them or all of them, about what they're going to say about how dumb I am and how this is just ludicrous. I noticed they were doing the same thing with Mr. Carter, and there may be colorful metaphors and, other examples that this is like this and this is like that and, blah, blah, blah. I'm the one in denial and who knows? I don't know what'll happen, but that's really none of my business. That isn't going to change. And again, I hate to keep agreeing with I don't hate to agree with him, but again, agreeing with Mr. Carter, that's the facts that we have. And he's right about another thing. This I want, while you're listening to me, please consider this is the last time that I will get to speak to you, just like it was for Mr. Carter. The state, right or wrong, gets the opportunity to speak to you last. They get to sift through every single thing we've said and try to find a way to knock it back and bring you back into the fold and tell you how crazy we are and tell you that we're throwing out things like red herrings and, putting, trying to put smoke in the air so that you'll be confused. That's not what I'm doing. In fact, we're going to go through their evidence. So you won't have to hear, it won't have to be my words. It'll be their own people's words, what they said, what they failed to say, what they proved, what they didn't prove. And that's what you need to pay attention to. Not me. I mean, well, I hope you pay attention to what I'm saying because I'm trying to put it all together for you. But so let's look at what Ms. Bell is charged with. She is charged in count 1 with murder in the 2nd degree. I'm not going to spend a lot of time on this because this particular charge we can't even get to unless you find her guilty of count 2, because it requires that she be in the commission of cruelty to children in the 2nd degree by causing Caliyah McNabb cruel and excessive physical pain through infliction upon her of a blunt force trauma to the head. So, unless you find count 2, there is no count 1. And I hope you'll understand all this. This is a bit confusing. It's some of these charges are a little, well, I'd say they're kind of bootstrapped together, but that's just the way it is. So, and first of all, let me say this: if you find that someone else did this other than their claim that Mr. McNabb did this, then there is no case against Miss Bell, period. Because nothing that they proved would account for an accident or any of the other evidence that Mr. Carter put up, or I'm sorry, that during his cross-examination, or any other, if anybody else did it, you can just take Ms. Bell's and toss it out the window. So, but getting back to it, count 1 really is irrelevant unless you find count 2. And what is count 2? Cruelty to children in the 2nd degree. For that, on one specific day, 7th day of October, the day the child went missing, that she, with criminal negligence, and I want to read what criminal negligence is. Let me read the charge first. With criminal negligence, caused Caliyah McNabb, child under the age of 18, cruel and excessive physical pain to the infliction upon her of blunt force trauma to the head. Well, what is criminal negligence? That is an act or failure to act which demonstrates willful. There is no willfulness in this case with regard to her. Wanton or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Now let's talk about that. A reasonable expectation. I'm going to argue vehemently, as strongly as I can, that under any circumstances, whether she'd been beaten, whether she had used drugs, whether he cheated on her, under any circumstances, how do you reasonably expect from what you've been given that someone is going to take your infant and do what was done to that child that you saw in those autopsy photos? Who can reasonably expect that? She didn't. She absolutely couldn't even believe it. You saw hours of tapes where she literally says, I don't understand this. Obviously there was a lot of tears, a lot of emotion, and I'll spare you that reenactment. But she was blown away. And we all watch the news. I mean, domestic violence is it's not like this is the first, oh my God, this is domestic violence. I've never even heard of that before. We see it on TV daily. High government officials, athletes, performers, and it doesn't come out for months and months and months and months. I wonder, do any of those people think that someone might just go completely savagely insane and do something like that to their children? I'd submit to you the answer is absolutely not. There was an intervening cause here. I don't know who. And that, again, I'm not getting into that fight. What I do know is there was an intervening cause here far greater than, say, a mother who has 3 kids between the ages of 1 and 4 and a pool, a 20-foot deep pool in the backyard, and she just ignores them for hours and hours and hours. Drowning seems kind of likely. Or if you want to let your child go swimming in the ocean where people are chumming for sharks, well, there's a good chance that there's tons of blood in the water. That's probably a bad idea. This is not that situation. This is not at all that situation. Because she was beaten, because she did drugs, she's supposed to know that him or anyone else would do that, commit that heinous crime, beat an infant so savagely that her teeth came through her tongue, lips, that she's unrecognizable. And again, we don't even know what happened there. We have no motive. They can't establish one. They haven't even offered one. Not even a glimpse of one. So how is she supposed to know? The answer is she didn't at all. Count 3 is contributing to the deprivation of a minor because allegedly on this date, this isn't just like all the time, okay? You got to remember, these are specific dates. This child went missing on October 7th, 2017. That she allegedly willfully failed to provide proper parental care or control for Caliyah. I'm going to stop there because there's a lot of ands in this one. And when there's a lot of ands, that means every single thing needs to be proven. Failed to provide proper parental care. The child was sleeping by every account, and so was my client. She took roughly 4 to 4.5 hours to sleep. 4 to 4.5 hours. I get it. She's an infant. I've had many kids. Well, I haven't. My wife has. But those moments when you finally get a newborn to get a couple hours of sleep and you fall asleep so that you're not sleep deprived, that doesn't make you a bad parent. It doesn't make you failing to provide proper parental care. No. I think if we put our common sense hats on, we'll all realize that we've probably all taken, with newborns, young children, infants, we've taken that time to sleep when we can, when they're sleeping. And as far as she knew, that child was sleeping. She said to Chris, Go check on the baby. It wasn't as if she was asleep for 24 hours or she was missing from the house or she just didn't care or she was knocked out cold. She went to bed at 5:30 a.m. and she was up and calling 911 at, I believe it was 10:32. That is hardly failing to provide proper parental care. But in addition to having to prove that, they have to prove that she failed to provide said child with adequate supervision necessary for such child's well-being. Said act, in the failure to do that, the act, apparently, and I'll use the same argument. There was no failed supervision. She was down the hall. She was sleeping. Mom had a couple hours to sleep. She took it.
Where are we
That does
going,
not make her
cameraman?
murderous or set the table for a murder in any way, shape, or form.
Sorry.
And that resulted in her being a deprived child. There's a lot of people out there who are going to be in a lot of trouble if that's the new state of the law. And of course, then it goes into in accordance with Code Section 1511.2 of the Fish Code of Georgia. But yet there's another and that act or failed to act. Well, they say that act, so we'll go with that. Resulted in the death of the child. No, I'll tell you what resulted in the death of the child. Someone taking that child and inflicting such unbelievable force, whether it be a fist or, as the ME said, a boot or a heavy object, over and over and over, to inflict such incredible damage that it caused death. It wasn't my client sleeping for 4 hours. And let me say something else. I've got a lot more to say, actually, but my client getting beat up did not cause this child's death. My client, even using those drugs on the occasion she did, child didn't ingest any of them. The child, that didn't cause the child's death. Her being cheated on, her living in a mobile home, did not cause that child's death. And last I checked, living in mobile homes, coming from an abysmal socioeconomic life or demographic, being beaten and not reporting it as she probably should have done, those aren't illegal. They're not. Because that's the smoke and mirrors they want you to believe. What caused that child's death is, simply put, according to the indictments, blunt force trauma to the head. And you saw it. That's what caused the death. And there has not been one shred of evidence that suggests that my client, Miss Bell, did anything to harm that child. So as much as they want to pack on for how horrible a mother she is, she didn't cause that child's death. And they're going to say, well, she set the table. She set out the steak knives for a steak dinner, and somebody at that dinner table picked one up and stabbed the person next to him. How is that her fault? It's not. It's the crazy person sitting there that picked up the steak knife or the wine glass or the plate or whatever they used and smashed it over their head or stabbed them or did whatever. That's who killed Caliyah McNabb, not my client. But the mother can't go. It couldn't just be dad in this situation, because they really don't know. And they weren't taking any chances as a state, taking any chances here to, so they just accused them all. Made up what they could. There is no bright line test that I could find on what is reckless disregard or any of that stuff. You folks will be making the decision in this case, not every case or any future or past, whatever cases, this case. It'll be up to you to make that decision. But I submit to you that as far as her indictment, there just isn't anything there. Ms. Zahn's going to argue it, and she will do a good job, I'm sure, saying that if this, then that, and but for this. Well, guess what? That's not how we operate. There's a whole lot of what ifs and but fors that could prevent a million tragedies. But we don't blame everybody. You know, what if somebody had done something aboard the planes in 9/11? I don't know. Then, you know, if they live, then should we blame them? No. No, we shouldn't. It was the people who hijacked them and ran them into buildings. That's who we blame. That's who we hold accountable. My client got up. She called 911. Well, first she called her father. Did you come get the baby? Did you, because there was some discussion about that. She kept hoping and hoping Caliyah would be found because all she knew was that she had gone missing. She asked detective investigator Alexander, the lead investigator, can I have your number? Can you update me? Have you found it? Have the dogs found anything? Have you found anything? She had no idea. I mean, I hope this part of my argument is you're saying to yourself, yeah, I got all that. But in case you're not, she stayed interested. There was no complicity. Well, we'll get to that. Bear with me just a moment, folks. Well, there's a few more charges I want to go over with you. You're also going to hear charges about intent. Again, I've made my arguments on the indictments, but intent is an essential element of any crime, must be proved by the state beyond a reasonable doubt. You're going to hear that. You're going to hear that there is no presumption of any criminal intent. The defendant will not be presumed to have acted with any criminal intent. You're going to hear things about guilt by mere association. Mere association by a person with other persons involved in the commission of a crime, if in fact he did have anything to do with it, which again, like I said, I'm not involved in that. Without more, will not authorize a jury to find such person guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Then you've got something called mere presence at the scene of the crime. Basically, what this means is that my client being associated with him, my client being in the trailer, does not make her guilty, no matter how hard they're going to try to tell you she set the table, she did this, if not for this, then that, and whatever arguments she's going to come up with. Grave suspicion. Facts and circumstances which merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize conviction of the defendant. That is a very important charge. And I hope you listen clearly. I won't reread it a dozen times, but grave suspicion, it's not enough. I can't stress these things enough. The burden is incredibly high for them. She's going to say, well, it's not a mathematical certainty. It's not this, that, or the other thing. No, it's not. But it's so high that if you're wavering, unsettled, dissatisfied, or have grave suspicion or speculation or conjecture, you can't find her guilty by law. If you want to disobey that, I can't help that. But that will be the law you're read. Not that I think that it's going to be that close. I hope. Let's see, bear with me.
I don't think I've ever heard an attorney say, well, if you want to break the law, then I guess you're going to break the law.
In a minute, I want to go through exactly what evidence did come out. I just don't want to miss anything that
Is he going to defend them if they do? It's weird.
just going over again the situation. Please remember, the medical examiner, she did the autopsy. I think there was probably 2 or 3 critical elements, definitely 2. One was that there was no sign of any previous abuse. The other was that she reviewed the pediatric records from like the Thursday before. Just a couple, that had occurred just prior to her death. The child was fine. The child was in good health. You heard that from just about everybody. And the state brought that out. This child was fine. To show, I guess, in their effort to try to, convict Mr. McNabb, to show that it wasn't some, to exclude the possibility of she might have been sick or whatever. So the point being, the child was fine. Well, what does that tell you? Clarissa, she's fine. And she was fine, and she's 2. So that kind of flies and contradicts their argument about my client being so bad and her situation being so bad that this should have been seen a mile away. And again, I don't think anyone would have seen this coming. And again, whatever drugs she did and however many, times she did them, the only thing that really matters is what happened on that particular day. And on that particular day, whatever she did, however little she did, was so bad that she was able to do what she had to do. Bless you. And she stayed up with the baby until 5:30. The baby didn't die of the drugs that my client did. The baby didn't die of any previous beatings that my client sustained. The baby didn't die over my client sleeping for 4.5 hours. Again, we know how that baby died. We saw how that baby died. And may she rest in peace, but it wasn't right. That's simple as it is. It was heartbreaking. My client is guilty of one thing. She is guilty of being a foolhardy, almost, and that's putting it politely, very foolish young woman who thought she was in love and who has no idea what love is. Love is not being in love. Love is not caring about somebody who is literally doesn't care about you more than they care about a car, or their kids more than they care about a PT Cruiser. And you heard those tapes and her begging. She wanted a nuclear family. She wanted what she didn't have. Her father did the best he could, but that's tough. That's real tough. She didn't even know who her mother was until she was a teenager. And unfortunately, that led to the situation between these two, which they didn't even know about until after they were seeing each other. But none of that even really matters. We're here about Caliyah. But the point is, my client foolishly, naively thought she was going to fix a person who is serially cheating, didn't care about her at all, as per every action just about that he took. She didn't know. You saw how, and I'm not trying to disparage people of lower socioeconomic levels or income levels, but you were out there. You saw how folks out there live. They don't have the same norm that many of us do. Many of the things that we think of as obvious aren't obvious to them. Out there, even in some of the churches, they advise, well, you stay and you work your problems out with domestic violence. Oh, he's a drinker. Well, then you pray for his soul, because divorce is a sin. I mean, they weren't married, but the point being, they have children together. You stay together. Or in her case, you just have no guidance whatsoever and you do the best you can. But you heard how many times she said, Daddy, that's what she called him, Daddy, please come home. Please come home. She was just a fool.
Gross.
She was a fool to ever think she was going to have a nuclear family with him. That I will give you. But that is all she's guilty of. She never wanted anything to happen to her kids. And she never thought in a million years that their father, if he even did it, could do something like that. She never, and this goes back to what I was saying earlier, the reasonable expectations. And you see that in some of those tapes, when she starts hearing things and seeing things online, she takes a phone call from him and she gives him the what for.
He gives her a black eye.
There's no other explanations. Now, I'm not saying there isn't other explanations. I'm simply saying what she said. But she starts asking all those right questions, which evidences to you, since you heard her, she didn't want anything to happen to this child or her other child. And nothing did happen to the other child, which begs other questions. Why would you harm one child instead of both, or all four of them for that matter, or everybody? And if it was him, how about all three? I don't know. But that's just it. We don't know. But I get distracted. So let's focus back on these counts, this criminal negligence and this disregard, reckless disregard. She didn't see any of this coming. That's all there is to it. Was she stupid for loving this man? Probably, yes. And she's probably behind me right now making some sort of face that isn't real happy about being called that. But the point is, because she was in a bad relationship, Ms. Zahn's going to tell you that bad relationship where she suffered domestic abuse, but the children didn't. There's been no evidence whatsoever that either of those children did. So if she wanted to take that, I think it's crazy. You all may think it's insane. We might all think it's stupid and crazy and unbelievable. But it's obviously rampant. Here in the United States, we have a whole month devoted to domestic violence. It isn't something that just happens here or, in sporadic times. It's all over. It's an epidemic. So again, well, some other things I want to point out, kind of along the lines of the investigation. I don't know that it really particularly matters, but my client was let's see exactly what. A lot of witnesses.
Well, you didn't ask a lot of
Gary
questions.
Morgan, person put on what I thought was a most entertaining and amazing technological 3D look at the trailer. Stated, my client was 33.529 feet. It's pretty exact from the location where Caliyah was sleeping. Also said that there was 3 walls, 1, 2, 3, between where my client was and the baby. Now keep in mind, the baby was also sleeping really close to a wall unit AC. I don't know. We don't know whether it was on or off. We just don't. It's Georgia. It could have been 100 degrees out that night or 50, but we don't know. But if it was running, a wall unit in a trailer, I'm guessing there could have been banging and rattling and all kinds of racket going on back there. The 2-year-old didn't wake up to it.
Maybe.
So again, this goes back to, should my client have known? No. Again, there is nothing wrong with getting a few hours of sleep while your infant is sleeping or your newborn or toddler or whatever. Parents are allowed to sleep. Now, granted, you don't get much when you got little kids, but we're not talking about 6, 8, 10, 14, 18, 24 hours, 4 to 4.5 hours. That's it. But the state's going to try to extrapolate that out like they will with everything. My client, there's no evidence. My client was so strung out on drugs that night that even if she were sober, she could have had any idea that any of this went on. That's what you need to think about. Because that's not how they're going to bring it out. They're going to be like, it was doing the drug, they package it all up, like I said, like that nice plastic wrap set of chicken breasts. Doing drugs, getting beat up. She clearly saw this coming. No. So what do we have? Let's go through. 911 operator was the first witness, and that was my client calling because she worried sick about her kids, obviously. Tim Bell, he did have quite a bit to say, and he pulled no punches. But he did say he'd never seen my client abuse her children, or even that he had ever seen the children abused, period. And that she wasn't a loving and affectionate mother. Did she have problems? Sure, she did. And like Mr. Carter said, we made that known from the beginning. That's why halfway through this trial, I started thinking, gosh, I got to find something to say to half these witnesses other than no questions. But it didn't apply.
That is all you
have questions for people when they were talking about with these 20 maps over here, where was this and how did this happen? My client wasn't charged with any of that. And I hope y'all understand that. If not, I don't want to take all the blame, but I went through the indictment to let you know my client isn't charged in any way, shape, or form with committing the act. Just with however they're going to phrase it, setting the table, which of course I've gone through, and I hope that you are on the same page with me on that. He confirms, yeah, she called me, and then I told her, get off the phone right away, call 911. Johnny Evans, owner of the mobile home park, wasn't much there. He owned the mobile home. and this again is for my defense, not necessarily for the
I might drink it.
There's another 911 operator. She wanted her kids back. She was having a little back and forth with her father. Understandable. It had to do with the fact that surprise, surprise. Tim Bell did not really approve of Mr. McNabb. I wonder why. If you're a father, and you know your daughter's getting beaten on and living over there, and that's with him, with what was going on and all the shadiness and whatever, I'm pretty sure you're going to be upset. And you're probably going to take the car back. And you're probably going to question, as I asked him, why are you paying for everything? Good question. Wish I knew that myself. But they're my grandkids, and I'm not going to let them suffer. So there were problems there. I'm not going to, that doesn't make my client guilty of these charges. Not even a little bit. Derek Bartlett. He answered the custodial interference call. Now this is one where he came out and he said, maybe we should do this as a, work this out, instead of anybody going to jail or whatever. And my client agreed. And the kids ended up going with their dad that night.
No, he didn't.
I'm sorry, with her father, Tim Bell. Yes, sir. Megan Sorrells, again.
6. I think
she said they were always, that Cortney kept them always fed, clean, brought supplies, etc. And also that when they were having problems, there were several witnesses, and I'll try to condense some of these, that said, yes, when they were having the problems, Cortney would lean on us. That's a responsible act. If you're going to have the problems, take advantage of your family. And folks, I could go on and on, but I think I've covered a lot of this. So I'll leave you with this. Those charges. I've gone over them. I've discussed why I believe my client is not guilty of these. And I'll ask you, to go back in there, deliberate, discuss all this. And I will ask you to return a verdict of not guilty on all counts as to Cortney Bell. Please remember the intricacies of that, of what I've said. I don't know what the state's going to rebut with, but please understand one thing. Nothing my client did caused that death. We all know, all of you know what caused that child's death. And it's nothing that my client did or could have prevented. She had every right to keep her kids. There's no way that she could have seen an intervening cause like whoever did that to the child, whether it be Mr. McNabb or anybody else. And if it wasn't Mr. McNabb, there's definitely no way. And again, if it wasn't Mr. McNabb, then there's nothing for you to even consider. It's not guilty, not guilty, not guilty for my client. Very simple. So please try your best to remember what I've gone over. At least consider my arguments and my position on this on behalf of Ms. Bell. I thank you again for your time and your consideration. Thank you.
This time we're going to take a morning recess for a short period. Y'all go back into the jury room.
Well, I think you guys think that he did worse than the first guy. Yeah. Mad Hatter, no. We are just doing this because we were just filling in some space to wait and for the Adam Montgomery trial that's starting. They're seating the jury tomorrow, so I'm not sure if it's going to start tomorrow or Wednesday. My hope is Wednesday that they'll start with opening statements. So we are just going through the end of it, and if you know the update, don't spoil it. There is an update after the verdict that's very, very current about this case.
Don't discuss this case while you're back.
All right. There's last looks at the ceiling. And hello, and thanks for joining us from the UK. The only thing that guy said that I would say he was right on is, if they're broken, I don't care if it's a man or a woman, don't try to change them. Don't try to change them. You can't, especially if they're hitting on you. Go, just run. Oop. Got a little too zealous there. Sorry. I hear him. So we'll do the state's closing. We'll fast forward, get the verdict. I'll give you the update. I got too overzealous and now I went too far back. That's the story of my life. Seriously. Maybe one day I'll get this down. I mean, don't hold your breath, but I might. My son's like, you can hold up and do precise scrolling. I'm like, every time I try, I screw it up even worse. There we go.
Let me make the comment. When the state starts arguing, I don't want there to be outbursts from the defendants or from anybody if you don't agree with what the state is saying.
I don't know where she is
If
this
you think
morning.
you are going to make an outburst, go ahead and leave right now. Is that clear to everybody? Okay, let's bring the jurors in.
Well, that's interesting. He didn't say that when the defense started with their stuff. I wonder why he's thinking who he's thinking is going to give an outburst. Is it his family? Is it her family? Friends? All right, we're getting the jury. The state was making me laugh because sometimes she was writing so fast and you could hear it in the
Everybody be
microphone.
seated.
Like, we can't pick up anything else, but
Ms. Zahn, you may proceed with your argument. She'll be here tomorrow. Maybe she's packing or something. Well, there's a different view.
Members of the jury, Caliyah McNabb was the purest, most innocent form of human life. If you just look at her little fingers, her little nose, her sweet little chubby cheeks, those precious lips on her, she was a little angel. She was a gift to Cortney Bell and to Chris McNabb. And like all newborns are, she was tiny, she was fragile, she was dependent on both of them. for care, for love, for nurturing, and for protection. Cortney Bell and Chris McNabb should have come in between anything, whether it be a drug, any sort of environment, to protect this child. And yet the evidence shows that when this child left the hospital on September 27th, she left those nurses there, those loving, caring nurses there that serve and care for newborn babies. And she walked out of that hospital, was carried out of that hospital by two people, unfortunately, Cortney Bell and Chris McNabb, and her fate was all but sealed. That child was doomed the moment they left that hospital. As they walked through that parking lot there at Piedmont Newton, and they got into what I like to call the meth mobile, the PT Cruiser, the one where Shane Kidd was sitting in the back with a broken jaw and a drain coming out of the back of his face. Who does that? Who goes and picks up a newborn baby, goes back to Eagle Point Mobile Home Park, and brings a child, an innocent, sweet child? You can almost smell her. That smell of a newborn baby, the way their skin feels, the little cries, the little coos, the way their little eyes open up and observe everything around them. They took pure innocence and brought that child into their life of hell. And you know, Caliyah may have had a mother who tried to love her. There's no question that her father didn't love her. There's no question that Chris McNabb did not love that child. Chris McNabb didn't love the child's mother. And we know that Cortney Bell believed that she loved Chris McNabb. But while Chris McNabb was chasing dope and chasing this lifestyle, his independence and his freedom, Cortney was chasing Chris McNabb. Cortney was following after him instead of putting her child and the child's protection and the child's needs first. She put that child in danger. She jeopardized that child's well-being. You heard her own father, as much as he loves his daughter, as much as it was painful for him to say on the stand, you heard his own words when he called 911 on October the 3rd and said, the way I see it, they've abandoned those youngins. They were dumping their children off just days after the little baby comes home from the hospital. 6 pounds. A 6-pound child that needed to be fed, changed, held, loved. We can only thank God that that little baby spent a few days with Megan Sorrells, because that may have been the only time in her 14 days that she was alive that little Caliyah was ever held, that little Caliyah was ever loved. Maybe just in those few days between October 1st and October 3rd, when she was left over there, dumped over there really by her mother, so she could go around and try to find her cheating boyfriend who's going from dope house to dope house and beating her up in between. Maybe. In fact, Megan Sorrells testified to it, that she did hold the child to her chest, to her bosom. And so maybe just in those few little days, those few hours of little Caliyah's life, did she know what it felt like to be loved, to be wanted, to be protected. And unfortunately, Megan will always regret that it got too much for her because she had her own children. And of course, she called and asked her mother for help, that she needed a break. And that set the chain of events in motion where Tim Bell said, y'all should have told me this earlier. Tim Bell is a decent man. Tim Bell cared about these children. Tim Bell came and got that car. Why do you think he took the car away from Cortney and Chris? Did they not need the car to take care of the child, to take it to doctor's appointments? He took the car away from Cortney and Chris because he knew what that car meant. He knew what that car was for them. It was their way to get around town and get from dope house to dope house and pick up dopers and bring them to their house. It was the meth mobile indeed. These children were only provided for, to the extent that they were provided for, because of the grandparents, because of Tim Bell. There was even some statement by Mr. McNabb, I believe in his final interview on December the 13th that he gave in 2017, that his father was helping, that his father would send money to help pay for the rent. Mr. McNabb, the defendant, had an opportunity to work. His father owned or worked in a successful business, laying pipe, I believe he said. He paid well. Chris McNabb was just so sorry that he wouldn't get up and go to work. He cared more about traveling around the community and smoking dope than providing for his children, even to the extent that on October the 5th, when Cortney's over at her dad's house and she's texting him, and we showed you that in the Facebook messages throughout that day, and she's trying to get him to come back to her, essentially. He's saying, well, why don't you just stay there? Why don't you and the kids just stay there? I love you, but I just can't be involved in y'all's life. The Bells win. I'm not going to be able to, provide, which is just silly. He had an opportunity to work and he didn't. He even said that, I believe, in the first interview, that he just wouldn't get up and go to work. Just didn't feel like it. There was just too much going on. Well, we now know what all was going on in the days leading up to little baby Caliyah's unfortunate and untimely death, because we know that he was traveling around using methamphetamine. And we know that he was, even in September, luring people to his trailer so that he could beat them up with brass knuckles and all sorts, exposing again his pregnant wife and the child that they had together already to this sort of violence. Now, keep in mind an important point as well, because it was raised, I believe, by both defense attorneys in their closing arguments, that there was no evidence that Mr. McNabb had ever harmed either of the children. Well, that's true. But you also heard evidence that Mr. McNabb was not involved in Clarissa's life for the first 18 months. So that makes it kind of hard for him to have abused the children when he's not even there for 18 months of her life. And poor Caliyah, she's only 14 days old. So it's really not a very strong point to make to say, well, there's no evidence that he had abused her before the night that he smashed her brain in, her skull in. He wasn't involved as a father. He sat there in his first interview and lied and told everybody how much he loved his babies. But the reality is, those are words and talk is cheap. He didn't love those babies. He didn't love Cortney. And he turned on that charm and that manipulation when he was sitting in that room with her, with the two of them together by themselves. Boy, he loved her then, right? She's going, what could have happened? What happened to the baby? Oh, baby, I love you so much. We need each other. We're going to get through this. Yeah, he needed her, all right. He needed somebody to make sure he wasn't busted on his faulty timeline. Yeah, he's a manipulator. He's a good liar. We could maybe cut the lights a little bit. So first I want to talk about McNabb. And I want to reiterate the point that not only Judge Ott has made, but also the point that the defense attorneys just made to you. And it's very important in this case, and that is that they are charged differently. So you know that Mr. McNabb is charged in the indictment with malice murder and 2 counts of felony murder. So he's charged with killing this child. She is charged with murder in the 2nd degree, which is a different type of charge of murder. That's essentially that she was negligent in caring for or not caring for this child. And because of that negligence, this child died. So when we talk about Mr. McNabb's case first, we're going to talk about him. The evidence I'm going to talk about, the arguments I'm going to make now, first are going to be applicable to Mr. McNabb's case. And then I want to talk about Ms. Bell. But with respect to Mr. McNabb, this is a quote from his December 13th, 2017 interview. I think it's great. He says, and the evidence is evidence. I can't argue with evidence, but still though, like just because all that, anything that might have been around was mine, doesn't mean that I had to be the one to do it. It doesn't mean that I'm the one that done it. Yeah, it's a very strong reason to believe that I did it. He knows how powerful that evidence was, that his child is found in his bag with his clothes. He's conceding that by that 3rd interview. Completely innocent, completely defenseless Caliyah. She had absolutely no home. She was born just weighing 5 pounds and 6 ounces. She was discharged to this environment. This is the place where she was brought home to stay. If you can see there, of course, we know that there were some clothes that were tossed around. So we're certainly not suggesting that this is the way the home looked on the night of the 6th or even the early morning hours of the 7th. But you can clearly see Mr. McNabb in the bottom left corner of this photograph pointing this out to Jeff Alexander. And of course, you can see the little sleeper that she was in. And in that sleeper was this item that was introduced into evidence as State's Exhibit number 63. And that was the actual bedding that went in the sleeper. And we showed you that earlier. And there was no evidence by looking at this sleeper whatsoever that baby Caliyah had suffered any sort of injury inside of this sleeper where there would have been a lot of blood or anything to test there. Of course, had there been blood, we know it would have been baby Caliyah's blood. But even if you look at this photograph close up, and we've introduced these photographs for you into evidence, and you'll have all of this evidence when you go back into the jury deliberation room. But you can see in States 122 and States 123 that around the area where the child was found or was sleeping last, there's no evidence of any crime scene. There's no blood there. So that becomes relevant when the law enforcement officers are being criticized by the defense because they didn't search the whole trailer for a crime scene. Well, there were tons of officers there in the trailer that day. Not only Investigator Alexander and Mickey Kitchens, but all those deputies, many more than what you actually heard from on the stand. You heard that there were others that were out there as well. Several family members were there as well. Everybody, besides Chris McNabb, was diligently in that trailer looking for what possibly could have happened to this child. And so there was no quote unquote crime scene. And that again goes, it's consistent with the evidence from Dr. Darisaw that this was a closed wound to the head. So there wouldn't necessarily be a crime scene. There would not be blood that you might expect, even though the internal injuries were horrific looking. We saw her brain being essentially poured into a cup, but that was all contained inside of her head. And she has passages like we all do, nostrils and a mouth where blood could have escaped. And of course, the child was wrapped with clothing, which would be highly suggestive that the child was killed there inside of the trailer. It certainly would not make sense that a person would grab the child, grab the bag, just randomly grab 3 items of clothing, then take the child outside and kill the child, because it appears, although there's no requirement that the state proves where the child was killed, but it appears that those items were used to contain the blood to make sure that there was not a crime scene. Now we know the child was abandoned. We heard testimony from Megan Searles, we heard testimony from Melissa Davis, and we heard testimony from Tim Bell. They all say that they cared about that car. I believe it was Kim Weatherford that testified that Cortney Bell even said, we'll trade you the kids for the car. Mr. Tim Bell actually says that it was the defendant, Chris McNabb, that said that. But they were certainly interested in getting that car. And we know that also from the text messages or Facebook messages between Cortney and Chris on the 5th, when he's trying to tell her how to sneak the car out of her father's house. And he's trying to say, basically, if you get that car, then I promise I won't beat up on you anymore. I'm sorry for everything I've done. I just need you to get that car. That's all he cares about is the car. That's his ride around the community. She even calls him out and says, all you care about is that car. And that's in the context of her offering to do sexual favors. She's doing everything to try to get him back to her. And he's like, not now, not now. We have time for that later. I want you to get the car. That's all he cares about. Now, Megan Searles, of course, it was hard for her to come testify. That's her cousin. But she told you that the kids have been dropped off and had not been picked up for quite some time. So we know that was between the 1st and the 3rd. And we know that Melissa Davis was the lady who lived up at the top of the hill, and that she came down there on that morning to try to help look for the child. And she had contact with Chris McNabb, who said, they're going to think I did it. First thing he says to her. Now, we know that they also knew defects could take the children because Cortney Bell actually says that in her statement. She says, we got to get our babies home, Daddy. Defects could take them. So if she's aware of the fact that their parenting or lack thereof is going to allow the law to come take her children, and the defense wants to argue that that's not negligent or neglect, that's a big problem. How do you reconcile those two? She knows. She knows that she's going to lose her children. The child goes from the hospital, as I said, to hell. Here you can see the picture that Mr. McNabb used to update his Facebook profile, 5:51 a.m., just hours before the 911 call was made. If you have a Facebook account, it's interesting. You scroll through, if you ever scroll through your Facebook account or your Instagram or whatever social media application you might have. And one of the most popular posts or photographs that are on social media are of newborn babies. People are so proud of them. Look at my grandchild, or even pictures of, from in the hospital. They'll show the baby, not hopefully being birthed, but right afterwards being held by the mother or the father. Was Mr. McNabb the person that, is being described as a proud father? Was he posting pictures of his new baby? No. He's posting these kind of pictures of himself. Look at me. Look at me, Courtney Morris, who I'm trying to hit on. There at the house in the trailer with my 2 kids and my wife, just hours before my child is deceased. He's all about him. I mean, it's clear in this trial that, let's talk about the things that we've proven before we even get to the murder. We've proven that Chris McNabb is all about Chris McNabb. That's all he cares about. That's the only thing that he cares about. He's very much a self-preservationist. All this fake crying and fake tears that he did in the interviews about how much he loved his children and that he did in the courtroom are a joke. They're not real. I would not say the same thing about Cortney, by the way. Cortney legitimately cries during, not only on the 911 call, you can hear she's upset. You can see that in the body camera videos when the police just get there. She is genuinely concerned about where her child is. And she is genuinely concerned in the interview. On the first interview in particular, on the 7th. Her tears are real. I would imagine that some of her tears in this courtroom have been real because she's seen for the first time what exactly has happened to her child. But he's just acting. And you can hear that on the phone. You can hear, and he can shake his head at me all day long too. But you can hear that on the phone when he gets on the phone and he starts with his tears with her. And then as soon as he switches the subject back, I love you, baby. He's off. He can cut that off like a water faucet. It's just manipulation is all it is. And then there is, the hookah, the drug paraphernalia that he dumps out in the woods. He's hiding all that on that particular day. But we know, and you've heard testimony about them smoking dope inside of the residence. You've heard Shane Kidd was over there and Matthew Lester, and they were smoking methamphetamine. You've heard Craig Weatherford's come over there and smoke methamphetamine. So that house was, sort of a den. It was one of the little hot spots in town, if you will. you heard about some of the other locations where you could go and smoke methamphetamine. And, what's interesting about that is somehow we've lowered the bar now, and the argument made by Ms. Bell's attorney in closing argument is, if that's, bad parenting, then we're in trouble. There's lots of that going on. Well, it is bad parenting. That should be crystal clear. That shouldn't even be argued or disputed by anybody. Anybody who brings a child into a home where drugs, we're not talking about marijuana, and I'm not saying marijuana is good either, but there's a big difference. If you want to smoke marijuana versus smoking a drug that changes and alters your awareness. Chris McNabb is talking about having out-of-body experiences with these drugs, like weird stuff. I knew exactly what I was doing on both sides of my alternate universes, my out-of-body side and my real side. That's just some wacky stuff. You heard these terms about people that are wigging and people that are, whacked out on these drugs, and that's a real thing. Independent of the way the drug affects the body, you've also got the fact that they're going for days on these drugs and lack of sleep. So I can't emphasize enough just how the use and the smoking of the methamphetamine in and of itself is such a horrific environment for a child to be raised in. Because if you think about it, just to the points that were made by the defense about the neediness of a newborn child, needing to be cared for every couple hours, needing to be changed, needing to be fed or held or rocked to sleep, or given a bottle, whatever it might be. Children are high maintenance when they're young children, which, by the way, also sort of defeats the argument that anybody kidnapped the child. But it's a true fact that this child needed a lot of attention. Well, why would it then not be cruel or neglect to alter your state of mind, to make you agitated or irritable, to make you in a place where you might sleep for days on end because you've been up for 2 or 3 days? All of those things are factors that should be considered in terms of the environment that they brought this child into. But they also brought this child into an environment where there was, cruelty inside of the residence. We know that he's beating somebody up with brass knuckles just days before inside of this trailer. And having Cortney and Clarissa come pick him and Shane Kidd up over off Henderson Mill Road so they could get away. What a wonderful thing to take your 2-year-old daughter on a field trip to go pick up daddy who's just run through the woods after he beat the living daylights out of somebody and he's hiding from the police like a coward. There's blunt force trauma in this case. There's no question that the state has proven this is a homicide. There's no accident. There's no cover up. The defendant said it was no accident. We know the little sister didn't drop her and cause these injuries. We know that they were severely inflicted injuries. In fact, Dr. Darasaw testified that there was no features of a laceration on the child, but an incision of some sort, that it was a closed head injury, that it was a crushing injury, that there was multiple blunt force possible in this case. In other words, multiple blows that would have caused these injuries to the child, that it appeared to be a significant crushing. She said this looked like a crushing case to her. Somebody crushed this child's head in. It's been proven how she died. We hear all these defense questions. Who, what, when, where, why? I can answer them very quick. Who? Chris McNabb. What? Blunt force trauma. We don't have to prove what instrument or object was used. It could have been a hand. It could have been brass knuckles. It could have been his shoe. It could have been that he took the child and slammed it against the front porch railing. It could have been that he took the child and slammed the child against the bathroom sink or the bathroom tub. We don't have to prove the instrument. Why? Motive is not required, but I'll give you several whys. Because he's a violent person. Because you've seen it. He has a fuse that is very, very short. You saw him slam his fist down in that interview room, in that second interview. I didn't kill my GD child. You saw and heard him on the 911 call with Cortney Bell. Or excuse me, not the 911 call, the jail call that we played yesterday afternoon. He starts going crazy on her. Yelling, screaming. You saw what he was capable of doing to his own hand when he slams his fist into the trailer. they are inside of the residence. We've heard testimony that he took his TV and threw it out of the window of the trailer. We've heard testimony about the fact that he beat the living daylights out of Matthew Lester. So he is a violent, impulsive, angry person. And you put methamphetamines, you fuel that fire up. That's like pouring gasoline on a fire. That would be a why. Although we're not required to prove motive. We're not required to prove it at all. And I'll get to that in a little bit when I explain the law. And the judge is going to instruct you on that. Where, doesn't matter where, if the child was killed inside of the trailer, if you took the child outside of the trailer, the where that matters is that the child was killed here in Newton County, because we have to prove that beyond a reasonable doubt. But other than that, it doesn't matter where the child was killed. Think about it. There's dead bodies found all the time. You hear that on the news. Found a dead body in the woods off of I-75. Found a dead body in a hotel room off of 285. You don't have to prove where the wounds were inflicted. You just have to prove where the child was killed. The child was killed in the trailer. The body was found in the woods. The child was killed outside of the trailer. The body was found in the woods. The state has proven beyond a reasonable doubt that it was blunt force trauma and that it was consistent with crushing. Now, what does your common sense tell you about the way and the condition in which the body of Caliyah was found? And that's very important because you have to use your common sense in this case. I mean, you can't just turn on CSI mode and try to have everything hand-fed to you and digested for you. You've got to think and use your common sense, right? Like the investigators did. It's been suggested that, this has been a guided investigation, that, Investigator Alexander just jumped to conclusions. Well, no, but he also looks at clues. I mean, you don't become a detective or law enforcement officer and throw your common sense out the window. When somebody has reported that their child has been kidnapped and the father is nowhere to be found on scene, and the mama's having to text him and say, "Where are you? They want to know where you're at. The popo's here. What's going on?" And he's running through the woods and running down Henderson Mill for some random reason. Well, that's called a clue in law enforcement. That's called a clue in every world. When he gets up on the camera that night, that's another example, by the way, of his impulsive, angry dramatization, if you will, of that and that. When he gets in front of WSB TV cameras and he's like, "I want my kid back. That's my child. I want my kid back." It's full of anger. That's a clue too. You look at that and go, he might have done it. It's evidence. That is evidence, by the way. So we'll talk about what circumstantial evidence is. But the defense characterizing this case is, a weak case because there's, no evidence. Well, the baby, the child, is found in Chris's bag with his clothes. That's evidence. That's very strong, very powerful evidence. Why do you think he wants to blame Shane Kidd for that? Well, let's look at what he said on October the 7th on page 35 of the transcript that we passed out. He says, "I went in through the woods. I went down there, and there's one place you could go to the right. And I think that it might go to somebody's house. I never go that way." We wanted them to know, I don't go off that way where the baby's going to be found tomorrow, just to be clear. I always take the first clearing. It's not really clear, though. It's kind of grew up a little bit, but you know what I mean? It goes down, and then it kind of goes up a little bit, and it goes straight to Henderson Mill Road. And Jeff Alexander says, that's the route I took. And I came out, and I took a ride on Henderson Mill, and then I went down all the way to the girl Sarah's house, and then Cortney texted, and I stood there for maybe 30 seconds. Cortney did a Facebook Messenger thing or whatever it was, and said the police are here, and they want to know you're at. So I was like, I'm coming. You know what I mean? And I turned around and went back. Now, he's giving very specific directions on how he went in the woods because he wants everybody to know, I didn't take this path where the baby is. And y'all all walked it. And if you remember, the baby was found under the log. And then when we hit Henderson Mill and turned around, we came back up, going towards the right to where the items were found previously from the Matt Lester incident. So he's already trying to make it clear. Now he's dropping little clues here as if it isn't a clue that he's going into the woods to begin with. We know from the case that McNabb cleans up crime scenes and hides items in the woods. Look at his statement on December the 13th on page 15 of the transcript that we passed out to you, Alexander says, what did you bring that stuff out there for? Because that was the day that me and Matt Lester got into it. And it was all his. It was a lot of his stuff. That bag was his. And whenever I kicked on the steps and he took off running, I figured he was going to go to the police. So I wanted to get all of his stuff out of my trailer, i.e. clean up crime scene, hide evidence. That way, after all the blood that was in the hallway got cleaned up from him and all that. Now, keep in mind, where's Cortney? Courtney's outside in the car with Clarissa per Shane Kidd, per Matt Lester. So we know that Courtney's not the one cleaning up the blood. The defendant's cleaning up his own crime scene, so he's capable of getting his hands dirty and cleaning up his own crime scene. That's very telling. I got the blood cleanup from the crime scene and all that, and that's when I took the bag out there because I knew if he went to the police and he would come back, that was his stuff. So that's proof right there that me and him got into it. But without that stuff around, I could deny it. That's how I was thinking at the time. I felt like he was going to call the police. So what he's saying is if I get rid of all the evidence, I cleaned up the blood, I get all the clothes, and then the police might come back and they might come back with him to get his items, I can deny it now. I've got plausible deniability, but I don't have the items inside of my home. And what does that tell you about the way Christopher McNabb thinks? There's those items and there's that trail. He says about those items, I find it interesting that he took all the items, the drug paraphernalia, the hookah, the wallet, and he wrapped it all up in the jacket, just like he did with his child. He said, I mean, anybody, if they're doing something wrong and they're on foot, they're going to go through the woods. Is that not plainly obvious to you all that he makes this statement? He's telling you, hey, guilty people, go down these woods. You know, when the defense talks about what's the evidence in this case, you've got to be able to see the forest from the trees. Yeah, they can talk about, oh, we don't know whose blood that was on the clothes in the bag. Well, we know they're his clothes, and we know that's going to be the child's blood. I mean, yes, maybe somebody escaped from a mental asylum, as they tried to argue earlier in the trial, and left their blood there because somehow baby Caliyah put on boxing gloves and put up a good fight. But that's not living in reality, right? We're suspending our common sense to believe these conspiracy theories that the defense wants to float out there. No, we know that the blood in the bag and the clothes in the bag are Caliyah's blood and the defendant's blood. So when you're looking at all of the evidence in this case and you see the forest instead of the individual trees, all the evidence is right in front of you. Him jumping out of the car, his bag. Makes you think of that Austin Powers movie where Austin Powers says, that's not my bag. Yeah, it's your bag. It's your clothes in the bag.
Hey, Roseanne.
And your hiding spot, the woods. So, you know, when you're talking about what is the state's evidence in this case, I'm not trying to belittle the burden the state has. I'm not trying to suggest you've got to have less evidence than beyond a reasonable doubt proof. But I want to say, duh, it's obvious. From the beginning, the police would have never looked out in those woods if it weren't for McNabb running through those woods. And by the way, McNabb apparently, you know, the defense just raised the argument about why would he put the child in his own bag? That's a good point. You know, why would he put the child in his own bag? He says that, or he does that because he doesn't think they're going to find the child. They didn't find these other items. They didn't find the camouflage jacket and the shoes and all that sort of stuff. He doesn't think. And think about it. He's coming down off meth. He's on meth. He's not thinking straight. He doesn't realize when he comes back and he has to tell investigators that he's been in the woods that they're going to go, wait a minute. Maybe we ought to look in those woods. He doesn't realize that. He thinks he's got that baby hidden away and everybody's going to go out and put flyers all over Covington and we're going to treat it as a kidnapping investigation. What does he say on December 13th? I just know that the first thing that always pops in my mind when I wanted to get, like, say if I felt like probation was going to show up one morning or something, I'd always go in the woods. I always went in those woods. That was the first place I'd go on foot if I felt like I was in trouble or something. Like just when I beat that dude up, I took all his stuff to the woods. You know what I mean? He also says on October the 7th, I'm pretty sure I was the last one that had the baby. I was the last one that held her. And remember, he's talking about a time frame between 3 to 5. And that's in the October 8th. That's the next statement that he gives on the following day after he's jumped out of the Chevron and he's been arrested. Why is that time frame important? Because he's the one who had the baby last. And so it doesn't necessarily matter when the child was killed inside the home, but the evidence has highly suggested that he killed the child inside the home and took the child outside into the woods when it was dark, way before 9:30 or 10:30 when he's going through the woods and Cortney's texting him because he had that flashlight with him. And why would he need the flashlight? That doesn't make any sense that he's going to run out of the house. But the first thing he's going to do when his 2-year-old child wakes them up, meaning wakes Cortney up, but he's already up, because we know that because he's on his phone texting Cortney Morris at 9:42 a.m. But why wouldn't you run outside? Your child's missing. Start banging on every trailer in the trailer park. Hey, come outside. Help me look for my baby. Has anybody seen anything suspicious? Does anybody know where there's a car? That would be after you spend about 20 minutes looking inside your own trailer, because who thinks that somebody's going to break inside of a car or inside of your trailer and take your baby? As much as the defense has tried to make this sort of conspiracy theory that somebody broke in and took the baby, that's not a thing. That's just not a thing. Nobody breaks in to homes and takes their children. Not unless you're like the heir to the Saudi prince and you're going to be able to ransom this child for a lot of money. Or maybe, that was been suggested that he had a hit on him. Well, he's broke as a joke. He's not Guzman. He's not El Chapo, right? I mean, he's not somebody that everybody's like, we're going to take him out and we're even going to do worse than that. We're going to kill his child. And then we're going to plant it in the woods that we know he hides stuff to make it look like he did it. We're going to kill his child and we're going to frame him. They wanted to take a hit out on him, which is there's no evidence of. It's absurd. It's not a reasonable doubt. Like, that's not something to go back and say, well, we don't know. It could have been the guy from the escapee from the mental asylum, or it could have been somebody who wanted to take a hit on him. That's not reasonable. That's not a reasonable defense. And the state does not have to disprove every single unreasonable conspiracy theory that the defense comes up with. Now, the defendant gives 3 different versions in this case, and I think that's very important, because if the defendant is a liar, then why should you believe him at all? If he's lying, there's a big problem, because an innocent man who just lost his child, who just woke up to find his baby missing, would never lie to the police. Yeah, he might lie about the fact that, yeah, I smoked methamphetamine last night. Okay, you don't want fine, whatever. But you're not going to run, and you're not going to give them very inconsistent versions of what happened with your child. And so I've got those 3 versions here summarized for you today, starting with his first version. And this would have been the one that he gave on October the 7th. Okay. And I don't know, can you all see that? Okay. October the 7th. I call this the fetter in the bedroom account. So the very last time that I actually held my baby in my arms and see the one that's missing, Caliyah, I was feeding her bottle on the bed in the bedroom. I mean, she was crying. You know how newborns are. They're always crying, especially when they're hungry. But I bundled her up like a little, what is it? Tight as a bug in a rug or something like that. I was thinking it was 3:30. But my baby's mother says it might have been probably around like 5 or something like that. My dad texted it supposedly 9:30. So that's his first sort of rendition or account of what happened. The first version. He's feeding her in the bedroom, somewhere between 3:30 and 5 o'clock, depending on whether he's right or Cortney's right. But, when you're up smoking meth all night long, you probably don't know what time it is. Because, again, Mr. Frost makes the argument, well, geez, every parent has to get some sleep. Right. But they're going to sleep at 5 o'clock in the morning. They're going to sleep at 5 o'clock in the morning because they've been smoking dope all night long. So that's not put this in the every parent category, the parents who go to bed at 9 o'clock and then have to get up several times and then hopefully get a couple hours sleep. These people are staying up smoking meth. And we know that they were smoking meth because Craig Rutherford said he came over there and they smoked meth. Remember, you also saw the text messages from that evening where Cortney, this is the day they get the child back on the 6th. The day the dad says, you got to clean up the trailer. Tim Bell says, you got to clean it up. I'm not going to bring the kids back unless you clean up your trailer. They clean it up. And then Cortney's texting or sending messages to McNabb like later on that evening saying, don't go smoke meth without me. Don't go smoke without me because I'm tired. And then the next one says, I can't believe you went and smoked without me. No, that's not neglect. That's not a bad environment to raise a child. And nothing possibly could go wrong in that home. Now, on October the 8th of 2017, this is I took her on the front porch account, right? So now he's saying, I knew it was anywhere from 3 to 5. I went in there and I picked her up. I fed her. I took her outside on the porch. Did anybody notice? He never said that in the first statement. Never said that. Front porch. Because Cortney was like, don't bring her in here because of the smoke. Take her outside. So I took her on the front porch and I brought her back in and I fed her in the room sitting on the bed. And when I got done feeding her, I can't remember if that was the first time that me and Cortney both changed her diaper or not. When I got done feeding her, I put her on the bed. I folded her blanket up the way, and that part was indiscernible, and I wrapped her up and I laid her down. So now he's changing the story. He's accounting for the fact that perhaps maybe somebody in the trailer park, somebody in Eagle Point, saw him go out on the porch with the child. The story is shifting. But of course, he's got to have Cortney awake now too, even though in the first statement, he was the last one that held the baby and seen her. So what is his third version? And by the way, it's sad to say that his defense was stronger when he was high on meth on the 7th and the 8th. By the time he volunteers to speak, reaches out to the investigator, to Alexander, he's really digging himself into some big holes in this last statement. Y'all heard that last statement. He just went on and on and on. And what investigator Alexander does is a great law enforcement technique. He just says, He doesn't stop him. He just lets him keep on because he's just digging. He is just digging his own hole in this last statement. He thinks he's helping himself out. He's sobered up. He's probably thinking, I've got a clear mind. If they think they've got DNA evidence on me, I'm going to sprinkle a few little things in there that'll help explain that. If they have a witness that saw me on the porch, I'm going to sprinkle a few things in that'll help me with that. But it's very problematic, and you'll see in this statement, this is what I call took her on the front porch, fed her in the bathroom. Notice not the bedroom now. Notice blood on her clothing, and oh, by the way, I had a cut on my finger account. Big shift in this statement, right? So here he says, it was nighttime. You know what I mean, all right? Well, not too long after that, me and Cortney had sex. I put those underwear back on, and baby girl was hungry. Not too long after that, she was crying because she was hungry. So I went back there and got her, and I was feeding her. Cortney made the bottle. I was back and forth. See, at first I took her when she was right next to Clarissa, and Clarissa will wait. She'll wake up. She wakes up during the night. A lot of times, she won't go back to sleep. So I took her out of there, and I took her in the bathroom and was feeding her in the bathroom. Well, she cried. Well, I guess I was feeding her. She stopped eating. So I guess she was full. So I took her back, and I laid her down again. I don't remember exactly what made me go back in there and get her. She was crying, but it was like she was crying louder. Like maybe she needed to be changed or something. There was one time, and I think I didn't mention this when I was questioned because I didn't remember it. But there was a time when she kind of was crying a little loud, and I didn't want to wake up Rissa. And I took her through the living room, and I took her out on the front porch. I didn't shut the door. Cortney knew. Of course, Cortney has to know about that, right? She was up. She knew. She was awake still. And I was rocking her or whatever. And she stopped crying. Now, stop right there. Did Cortney ever say this? Never. Cortney never said that Chris took that child on that front porch. So he's lying. Because you got to believe, Cortney was consistent. Cortney was consistent about the events that happened. I mean, I'm going to argue that Cortney is guilty of the charges in the indictment, but they're in two different boats. They're in two different culpability boats. And I want to make that clear about her. So she cared about getting her child back. She didn't understand, but she never said he took that child on the porch. And he says, that she knew she was awake still and I was rocking her or whatever, and she stopped crying. You know what I mean? It was a warm night. This is where it gets ridiculous. It felt good outside. You know what I mean? So I, figured a little fresh air. I know I needed it. And I was holding her. I just took her out there with me on the front porch. I didn't go off the front porch. Let's just be clear. I didn't go off the front porch. I just went on the front porch with the door open. Cortney was awake and I was getting some fresh air and enjoying it. I'm surprised he isn't telling us that he's singing lullabies to his daughter at this point. I stayed out there for maybe 5 minutes. She stopped crying after a minute and I took her back in. Members of the jury, I bet he took that child outside and that she did stop crying, but I don't think it was the same way that Mr. McNabb is wanting me to believe. I fed her a little bit more. I burped her, and me and Cortney changed her diaper together in the bathroom. And while we were changing her, she had on this long sleeve onesie or a twosie or whatever you call those things with the feet on them. She had one of those on, and it was white. And it had some like little hearts on it. It was the one that Cortney was holding when y'all came in, and he wanted something to try to maybe catch her scent and maybe be able to, you know what I mean? Now, if you remember, Cortney does talk about in her first statement that she was wearing this little onesie the last time she saw the baby. And then she says, I didn't get a chance to ask Chris this morning when the baby was missing, but he must have taken it off. She must have gotten hot because I found it laying in the bathroom. So she says that in the first statement. The child is wearing this little outfit, but now he's going to tell this whole story about her, how he and her took this onesie off, even though that's not what she said. That one. Well, she had it on, and while we were changing her, I noticed that there's a little red spot right here that was on the collar of it. Collar, close to the head, injuries to the head. And I noticed it, and I asked Cortney, I said, is that blood? It was a little bitty, you know what I mean? But I noticed it, and I was like, is that blood? And she was like, I don't know. And I was like, well, is she bleeding? You know what I mean? And she wasn't bleeding or nothing, I mean. She wasn't bleeding. She didn't have any wounds or anything. Like there wasn't no scratches on her that were bleeding or nothing anywhere in that area. But I had a cut on my fingers. And Cortney was like, well, maybe it's your finger. It was that one. You see the scar? So maybe, you know what I mean? I don't know. This is where he needs to insert. So maybe, you know what I mean? If you find my blood on that little onesie there, it's going to be mine, but it's totally innocent because I had a cut on my finger and Cortney was there. And we both remember this whole conversation, despite the fact that Cortney never told the police that happened. But she was like, maybe it's that cut or whatever on your finger. And I was like, all right, whatever. You know what I mean? And we took that off of her and I took her. And before I took her back in there and laid her down, I was holding her and I felt that she was shitting again. That's nice. So we changed her again. And then I took her and I swaddled her up in her blanket. And she had on that. I'll never forget what she was wearing. She had on that purple outfit. And it said, my daddy works out or something like that. I like that outfit. Very, very strange. Very, very telling. Why does he change his story? He's a liar. And if you can't believe what he's saying, and you've got a consistent version coming from Cortney, perhaps you should believe what Cortney says about the events of that evening. And you have to question, why is he lying? Why is he lying? Well, look what he looked like the day that the law enforcement officers came in. Look at him burying his head down. Do you remember when he went into the first interview on, October the 7th with Investigator Alexander? He's sitting like this. He's sitting in the room with his head down. And Investigator Alexander says, hey, I need you to take your hoodie off and take your hat off so I can see your face. So when the defense gets up and argues, as they did just a few moments ago, that this was a rush to judgment, this was a trial about their lifestyle, about the drugs, about the trailer park, and about the tattoos, that's just wrong. He wasn't a suspect in this case because of the tattoos on his face. He was a suspect in this case because he was hiding his face from law enforcement. From the minute that he walked up on the scene to you saw it, and you can see it in this photograph here, and you can see it in the interview. And he hid that child in these items because that's a guilty conscience. If you've just done something like that, you're in flesh and blood, do you want to look at it? That's why that child's wrapped up, aside from the fact that he wants to have, make sure that there's no blood dripping around. But that's why the child's wrapped up. He's hiding that child. He's hiding that child in those items because, again, he's got a guilty conscience. And we know, you've seen that, he jumps out and runs in this case. So we know that as well. So he's giving the three different versions of events. And notice by his last statement, as I mentioned, he's trying to find out what investigators know. He keeps saying, well, I don't know. What are y'all hearing? What do you know? Where's Cortney at? What's Cortney saying? So he wants to know what's going on in the investigation. And he's really agitated by the fact that Cortney hasn't been talking to him, and that she's out, I guess, gallivanting around with somebody else. All of a sudden, he's concerned about her. But the reality is he wants her to, wants to make sure she's not rolling on him or she's not, against him, because that's going to make it difficult for him. Now, if he is a liar, then you've got to understand why. He says, quote, I want the person that did this to be found, though. Probably more than anybody else, because, quote, it's the only way I'm going to get out. He says that over and over and over again in that last interview with Investigator Alexander. He doesn't want the person to be found who did this because they need her head on a platter, because they killed my precious flesh and blood, because they're a horrific monster, as he described. And you remember at the end of his statement, he's like, whoever did this is just a horrible monster. Well, he's describing himself. But all he cares about is getting out. He keeps telling Cortney on the phone, I'm going to get life. They could kill me. I'm going to get a bad sentence, basically. That's all he cares about, instead of finding out who the person is that killed his child. In the first statement, he lies. He says, quote, I'm just loving my babies. You know what I mean? Just regular family living all day. That's what he tells the investigators. That's regular family living, running around, doing dope, and that he's just loving on his babies. If you know anything from all that you've heard in this case, you know that Chris McNabb does not love on his babies. In fact, he pushes his pregnant baby's mother, the child's mother, in a very violent way. He admits that himself. So forget about what she says and what Shane Kidd says about him being violent. He admits that he did that. He corroborates everything that they say. He also says, the only thing I seen in the woods was a pair of men's brown shoes. I was like, why would somebody leave their shoes? Isn't that interesting in the first statement? He knows that he put the brown shoes out there. He has to admit it later on the 1213, I wrote 11213, statement where he says, Matt Lester, the shoes were his. Me and Shane Kidd took those out there. So he lied. He wanted investigators to think that those brown shoes that he knew he had taken out there on September the 13th belonged to the killer. Those are suspicious to me. I don't know why they were out there, and yet he put them out there. Matt Lester broke into my house like two and a half months ago. Matt Lester never broke into his house. That's a lie. The window was broken because he threw a TV out. The reason why he wanted to lie to the investigators is because he didn't want to admit that he really had no business luring Matt Lester to his home to beat him up like that. So he wants to make it sound like there's some beef between him and Matt Lester, and also provide, I guess, law enforcement the, alternative killer version. Just so happens for McNabb, Mr. Matt Lester was in jail. But there was no beef. Matt Lester apparently had an altercation or alleged altercation with Timmy Russian's mother. So this had really nothing to do with McNabb. Now look at October the 8th. Let's fact check him there. He says, and I took my flashlight. I took my phone. That was the only two things I had on me. He uses the word took. So I grabbed those things. I took those things with me. By the 8th, he's getting questioned, well, why are you using a flashlight? It's like 10 o'clock in the morning, 10:30 in the morning. I mean, I had the flashlight in my pocket anyway, so I just had it with me. And then by the 12:13, I had the flashlight, but that flashlight was already in those pants. So he just carries flashlights around in his pants, like I'm sure you all do, right? I mean, if you reach in your pocket right now, you've probably got a flashlight. And then he says, and I woke up at 9:30 with a text from my dad. So I went back there to make sure they were okay. I went back in the living room and I covered us up and I went to sleep. Maybe 45 minutes, maybe an hour and a half before Rissa woke them up. The Facebook records of Courtney Morris, actually, we know, show that Chris was adding her back to Messenger and texting her at 9:42 in the morning. So that's a problem. That's a big problem for him. He already had a ridiculously small time frame of which somebody could have broken into his trailer and come and kidnapped and killed his child. He's now shortened it tremendously and lied. So now we know he's lying. Now we know he's on Facebook Messenger. It was already unreasonable to believe that if he woke up, if he was light enough sleeping to wake up to a text, like a ding or whatever his phone did when the text came in, or actually it was Courtney's phone, then it's unreasonable to think that he was in such a deep sleep that he didn't hear somebody break into his trailer, right? Because the trailer is not wide at all. I mean, probably not any wider than between me and Miss Stone. It's not a very wide trailer. It's only, I think it was 50 something feet long, and even that, maybe 30 something feet. But this distance here would make it very difficult for him to have been awakened, I guess I should say, by this text message at 9:30 or 9:33, and then not hear the killer come in before the 911 call goes out. Now remember, Courtney says 5 minutes before she texted Melissa Davis at 10:24 is when she woke up by her child Clarissa at 10:19. It's a very short period of time. He can't be back in some deep sleep. And now we know he's up at 9:42. And what's really sick about that is he had just killed his child. And he's trying to hit on a girl. Now, the next lie that he's caught in on October the 8th was, I was asleep all up until the text message is the only time I woke up. Facebook records show that he was on Facebook updating his profile picture at 5:51 a.m. Is it reasonable to believe that Mr. McNabb went to sleep after that and was only awoken at 9:30 by his child or by the text message, and then later on by the child? He's been lying so much. Why would you believe him about this? On the December 13th statement, he lied. He said, when I first ran those woods, I was with Shane Kidd, and he was the one that showed me how to go through them. I walked over those shoes. The shoes were still there. I seen the camouflage jacket was still there. Well, Shane Kidd told you he never even lived there, didn't know that mobile home park, and so he's lying. He's now, if you remember, this is the time that he reaches out to Investigator Alexander, and he's trying to get Shane Kidd as a suspect. This is the guy who's like kind of his only friend, right? This is his uncle, he calls him. His brother, his dad, and his dad's brother were kind of close to Shane Kidd growing up. Shane is the only person that comes as a friend of Chris to the hospital. Shane is the one who arranges to have the trailer cleaned up so that the baby doesn't come home to an absolute train wreck. He gets the two ladies to come out there. Shane is the one that's sending him text messages saying, boy, you need to get on your knees and pray that baby's found. And then when he learns that Chris has jumped out of the car saying, boy, you need to get on your knees and beg for forgiveness because that baby deserves better than to be found in a duffel bag out in the woods. He's going to turn his back on Shane because now he's going to try to put it on Shane. Shane's the one who showed me where the path was. Shane's the one who had a hit on me per Courtney. Well, again, that's ridiculous. Why would Shane have a hit on Chris McNabb? There's absolutely no evidence of that whatsoever. And so when the defense keeps attacking the investigation because they didn't consider Shane Kidd a suspect or Matt Lester a suspect, it's just nonsense, right? I mean, that's just a nonsense defense. And we could take that entire trailer. We could literally put it on wheels and carry it to the bay over at the sheriff's office. And not only have kitchens, but have every crime scene investigator. We can get the city, we can get the GBI, and we can search it, and we can take Q-tips and collect every single tiny piece of trace evidence, and we can look at every single piece of DNA. And you know where you're going to find? Everybody that's gone in that trailer that smoked dope, that's gone over there to see those children, and it's not going to get you one step closer to solving this crime. That is just the biggest false truth that has been told in this case, that somehow the real killer's out there and their evidence is lying in that trailer or lying in those woods on those clothing. It's just not true. We called in the expert. We called in an expert from the GBI crime lab in forensic science, and particularly in trace evidence, and he explained to you that that type of evidence has no power to it unless you already have a suspect. You can't just find a random piece of hair or a random piece of skin cell and put it in a database and it tells you who a killer is. So the reality is that evidence, first of all, the defendant's DNA is going to be all over his trailer. So is the baby, so is hers, and so is half of the meth heads. And I use that term because they've used that term. He actually said methamphetamine is what killed my child. He refers to people as meth heads. But half of the meth heads here in Newton County have been in that trailer. So when does this investigation ever end? Do we just keep on interviewing every single one of them and find out if they had a motive to go into the trailer and kill a 14-day-old baby? You know, when I use that term, I will say this. You saw several people in this courtroom who testified who smoked methamphetamine. And while their lifestyle is certainly not favorable and it's not admirable in many respects, there are some decent things about those people, that they actually do understand that children are off limits, that you don't hurt children, that you don't kill your baby. There is some decency among those people. There's girls that were going out there. I'm quite sure if they were Shane Kidd's friends going out there and cleaning the trailer, they probably weren't living, you know, straight and narrow type lifestyles either. But they cared enough about the fact that a newborn baby was going to go to that trailer to go clean it up. More so than she did. More so than he did. There are decent people who are addicted to drugs. And it's a very sad lifestyle. It's a very sad background to this case. But it's not an excuse. The judge is going to instruct you on that principle of law. And it's very important. Voluntary intoxication is not a defense to a crime. You can't say, well, my bad. I was so high. I didn't know what I was doing. And I was addicted to drugs. And I was passed out on the couch. So I shouldn't be held accountable. That's not a defense to a crime. That's exactly the reason she should be held accountable. Because she was passed out on the couch. Because she chose to ingest that drug. And take her into another, you know, state of consciousness while her baby needed her. Baby Caliyah needed her. He says, now I know she's dead. Maybe I could find out who killed her if I just stayed out. Everybody who believes that, stand on your head. But the reason he jumped out of the car and ran was because he was going to get out his DNA kit and his magnifying glass and his Inspector Gadget jacket, and he was going to go around Newton County and solve this crime. Does anybody believe that? No, he was once again thinking about himself. The main thing that I had on my mind was that I would be better finding out who killed her than y'all would be. Oh, okay. We saw how that worked out, Mr. McNabb. Your December 13th statement. So far, your two suspects, Matt Lester and Shane Kidd. Sheriff's Office, what, 2? McNabb, 0, right? Like, you are not a detective. The one guy you're trying to blame it on is in jail. The other guy is like your best friend and you're betraying him. I just need to go ahead and just turn myself in and get it over with. That was my main intent when I first went up to that store. So somebody would call the police. He's actually trying to tell Alexander that he just decided to turn himself in. Even though when he walked in the store, he didn't say, hey, call 911. No, he's arguing with people. He's acting agitated in the store. He gets a Pepsi because he's been running for 1.8 miles all the way from the Marathon down to the Chevron. And he's hiding in the little bay there behind the car wash. He actually says, I wouldn't want to run because I could get shot, which A, is not true. They can't just shoot somebody who's running. That would be a problem if the sheriff's office did. But B, that's the reason why he stopped, because he knew he was in trouble. But he assumed automatically he was going to be charged with murder. That's a guilty conscience. He ran into the woods. These are all those text messages. I'm not going to read them all again to you, but I will point out that he does say here, when she's like, they want to know where you are, Daddy. What the F am I supposed to do? Who would say that? Who would say that? I love this statement down here. Baby, I can't go to jail when my baby's missing. Does he care about the baby that's missing, or does he care about himself? She's having to beg him to come home. Hurry up, Daddy. They're here.
That's so. She makes it sound so
No,
bad.
he's
Hurry
out
up.
there hiding. He's running. Could be hiding the baby from maybe the spot that he had. Maybe he's putting it in that better spot, that nice little deep hole that y'all saw. That's a good spot, by the way. That's a perfect size. Covered it up with some leaves, but yet they want you to believe that Mr. McNabb's defense wants you to believe that the real killer snuck back out there on the night of the 7th, when the whole area is swarming with law enforcement and all those citizens of the community that were getting on their feet and suiting up to go try to find the baby, went into a crime scene with a dead body. That makes a lot of sense. Yes, I'm sure that person went over there and planted this evidence to frame Chris McNabb. When he jumped out of that car, remember Pam Hamby's testimony when she said that he said, quote, if they find it anywhere near the house, they're going to blame us. That's his first thought. Not, oh my gosh, my child is dead. Take me there right away. Or, oh my gosh, my child's been found. But, there's conflicting evidence about whether or not he knew that the baby was dead. And it really doesn't matter. I mean, there's a lot's been made about that in this case. It doesn't matter if he knew that the child was dead or if he knew that the child was found. Either one of those should be news that would prompt a reasonable person, a person who had lost their child, a person who was desperately looking for their child, as opposed to riding around smoking dope with your aunt. You would not jump out of the car. You would want to be brought immediately to that scene. Keep in mind, they were traveling to go do news interviews. Cortney had gone and put all her makeup on. You see that, when she gets over to the mobile home park, that's when Walden, one of the deputies who testified earlier on, he was the one who actually saw McNabb coming out of the woods and said, what are you doing coming out of the woods, son? And described him as sweaty and had debris all over him. Walden was there when the baby was found, and when Hamby and Lauren Mackey and Cortney Bell all pull up, he asked Cortney, as Chris has a bag, and she describes it as a blue, she describes it to a T, the bag that the child was found in. So again, we know that Cortney's not involved. She's not trying to protect Chris. She's not, she wants to not believe that he did it, but she's giving information that's incriminating against him as well, such as the fact that he was wearing the blue camouflage underwear the night before the child was gone. And then, of course, we have this evidence, which is some of the most damning evidence you could ever have. The defense says, oh, they don't have much of a case. Well, except for the fact that he's referring to his child in the past tense. I loved her. She was my baby. She goes, what? Why'd you just do that? Why'd I do what? Why did you just refer to her in the past tense? I love you, Cortney. I love you. That's the rest of the whole spiel. We do this to our baby, Chris. I love you, baby. We got to stick together. That's all he cared about.
She's hilarious.
He kept saying they're going to try to play us against each other. He's got to have her be his wingman at this point in time. Still manipulating her. There is so much evidence against McNabb. Yes, it is circumstantial evidence, but we're going to talk about that in a second. Mr. Carter, I believe, said, well, they don't have any direct evidence, which is not true, because everybody who testified on the stand about a fact that they observed or they saw, that's direct evidence, right? Circumstantial evidence is when you look at all the circumstances, and there's a charge, and I'm going to explain that in a second, but the law is that direct evidence has no more weight than circumstantial evidence. They have equal weight. So that phrase, like, oh, it's just a circumstantial case. Circumstantial evidence is very powerful evidence, because if you think about it, if you got somebody that says, oh, I saw McNabb coming off the porch, and they needed to be wearing glasses, or maybe they were drunk, 3 sheets to the wind, their credibility, direct evidence depends on the credibility of the source it's coming from. You cannot attack evidence like that. He even said it. That's the first slide I put up there. You can't attack finding his child in his bag. There's no credibility question about that. That is what it is. It's found there. So circumstantial evidence is a very strong piece of evidence. We have lots of it in this case, as well as direct evidence. Now, with respect to Bell, she's charged with murder in the 2nd degree. And so is Mr. McNabb. So I want to make sure that everybody understands what murder in the second is. Mr. McNabb, incidentally, is charged with malice murder and felony murder. And I'm going to talk about their indictments at the very end and the law with respect to those charges. But Miss Bell is charged with murder in the 2nd degree. I'm going to start with that charge. and then go back to McNabb being charged with the malice murder and the felony murder. So what is murder in the second degree? Well, it's irrespective of malice. It refers to cruelty to the second degree, in that there was a death that was caused as a result of that cruelty in the second degree. So she's charged with, on October the 7th, that she did commit the offense of murder in the second degree when the accused caused the death of Caliyah McNabb, a human being, irrespective of malice, while in the commission of cruelty to children in the second degree, by causing Caliyah McNabb, a child under the age of 18 years, cruel and excessive physical pain through the infliction upon her of blunt force trauma to the head. We know she had blunt force trauma to the head. We know that's excessive physical pain. We know that she's a child under the 18 years of 18. And we know that we don't have to prove malice in this case. And so what has to be proved is that there was some sort of a cruelty to the child. So what would that be? In this case, it would be neglect. It would be drugs. It would be violence. She's accountable for her decisions. She chose to bring this child into this environment. Now, the defense says, well, she was being abused and she had a lot going on in her life. And yes, domestic violence is common. Yes, it's prevalent, unfortunately. And we see a lot of cases that we prosecute here in this county and in Walton County where victims are not allowed to get away from their abusers. They are held under the thumb of their abusers. They're afraid to go get a TPO. They're afraid to go seek help from the court system. They're afraid that if they call 911, they're going to get beat worse the next day. They're afraid that if they call 911, defects might come and take their children away from them. This is not the case here. There's a big distinction. She's getting beat up by him from time to time, but she keeps going back for more. He's trying to leave her. He is saying, why do you always have to follow me? He said that in the statement on 12/13. It's awful. He tells Alexander this, and again, I can't imagine why he thought these kind of statements were helpful to him. But he tells Alexander, she always wanted to follow me. She always wanted to be with me. I wanted my freedom. She wouldn't let me just go. And so what I figured out is if I just beat her up a little bit, then I could get away. Telling Shane, slam on the gas. And yet there she goes, and to some extent, Mr. Frost is right. In her naive, young, foolish mind, well, if I just keep, forgiving him and loving him and baby, come back and baby, I'll do this. And, it's just, she's pursuing something. And yes, there's some mitigating factors there in terms of maybe what her punishment should be if she's convicted. Yes. But you're not determining punishment. You're only determining guilt or innocence. Did she, in fact, do what she's charged with doing? The judge deals with sentencing. The judge can take into fact all the circumstances, like that she was young, like that Pam Hamby was a horrible mother that, didn't certainly teach Cortney how to be a mother. There's no question about that. But, lots of people are raised in single parent homes. Lots of people have that challenge in front of them. That doesn't mean that you get a pass to abuse your child or to neglect your child. You can't go pursue. She knows that's not right. She knows it's not right to neglect her children. She knows that drugs are not good to have around her child. And you know why she knows that? You know how we know that? Because she told us that. She literally says in her statement, when Alexander says you're being charged with cruelty to children, second degree, and then she says, well, I don't know what that means. And he says, it's contributing to the deprivation of a child. It basically means that because of the improper care and the things that have been going on in that household, that the children, and she interrupts him and says, well, that's the only thing I should be charged with. She's like, we've talked about that. I agreed to that. So she knows that she's neglected her children. And he says, who talked about that? She says, when we first met, I told you, I was completely honest. I told you all what all went on and all what happened and what all we did. And he says, uh-huh. And she says, I'm guilty of somewhat neglect because I did drugs. So she knows that. She knew that was wrong to do that, to involve her children around that. And she says, and I'm quoting, I agree that I did drugs. I agree that mine and his relationship wasn't fit for kids, but I was trying. I loved our babies. And she talks about how she had smudged marijuana throughout the whole pregnancy and she had done methamphetamine 10 times while she was pregnant with a child. She knows it's wrong. She knows what she's doing is wrong. And her naivety or her, pipe dream, and it's a good thing to want to have a father for your children. It's a good thing to want to have a home. I don't doubt that. I really don't. I don't doubt that she wanted this, kind of the all-American dream, mom, dad, 2 kids, and, the dog. But the reality is this guy is not capable of that. And so she's pursuing something and she knows better. And you know how she knows better? Because her family's telling her that. Tim Bell, it was no secret, had no love lost for this man, McNabb. He was concerned about his daughter's well-being, much less his granddaughter's well-being. But Cortney was wild, stubborn, strong-willed, and thought she was going to prove everybody that true love was going to win out in the end. And it didn't work out too well. Now she's charged with murder, and her baby's gone forever. And she's responsible for that. She's accountable. She chose to make these decisions. Cruelty in the second degree is with criminal negligence that she caused Caliyah McNabb, a child on the age of 18, cruel and excessive physical pain through the infliction upon blunt force trauma. Now, this doesn't mean that it's alleged that she inflicted the blunt force trauma, but because of her negligence, did the child suffer blunt force trauma? Well, if you look at what the definition of criminal negligence is, it's defined as an act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Willful, wanton, or reckless disregard. It's a disregard. Yeah, I know I should expose my kids to these violence. She said it. Yeah, I know you shouldn't be, smoking meth when you have kids around you. But, well, that's what this is. There's no intention required. We don't have to prove that she intended to harm her child. There's no evidence of that. If she had woken up and heard or seen McNabb beating on her child, I bet you she would have run in there and got into it and try to fight off McNabb. I don't think she would ever just sit and watch that happen. But that's not what she's charged with. She's charged with neglecting her child and putting her child in this situation. Her child, Caliyah, needed a mother who could hear her cries. That's what she deserved. That's what she needed. And she needed a mother who could protect her from the volatility of this man. And Miss Bell could not say to you that, I didn't know he was capable of hurting my children, because he's shown it time and time again. And she couldn't say, and Mr. Frost can't argue, but she was sleeping, so it's not her fault she didn't hear her child. She's passed out on the couch. She's using drugs. And it isn't about a singular moment. This charge is not that one singular bad decision, like what was alleged by the defense was, if you leave your kids, out in an ocean where there's sharks swimming around and they're being fed and there's blood in the water, yeah, that's a singular action. We're looking at a cumulative 14 days of this child's life. Everybody, like Mr. Frost said, everybody can make a mistake. I mean, my goodness, what if you accidentally left a candle burning and it fell over on the child and the child burned? I mean, there are going to be situations that are just accidents that nobody could foresee. But that's not what this is. I mean, we're talking about for 14 days what's happening to baby Caliyah. I mean, let's actually talk about what baby Caliyah's life was for 14 days. And the only person who really had control over that is Cortney Bell. McNabb's, anytime he sees Tim Bell, he runs like a chicken, like a coward. Guilty conscience, once again. Poor girl's walking around with black eyes the day that her baby's missing. You saw it in the trailer. Probably another reason he runs.
She is just calling him out.
Beats up on women and beats up on babies.
And looks right at him,
Has
too.
the nerve to go get a tattoo of the baby on his face to impress you all. Look, here's my tears I just tattooed. Just in case you don't buy my real ones, I've got them painted on my face for you. This is Caliyah's life. This is what Caliyah, for 14 days of her life, experienced. She was born, spent 4 days at the hospital. Thank the Lord. There she was, being fed, being taken care of, probably held by some sweet nurses there at the hospital. They are saints and angels. Then on October 1st, we know that this baby went and was dropped off over at Megan's. Megan said she dropped him off for a couple days. So there is 2 or 3 days where Courtney's running around chasing Chris, remember? She's texting him. It's all in those Facebook records. When you guys go back in the back to deliberate, you're going to get all this evidence. The only thing you really can't do with the evidence is you're not going to get a recording device or playing device, so you can't play all these interviews again. If there was something in question or in doubt, you could always request to hear that portion again. Hopefully you don't want to hear all 7 or whatever it is that we played 6 interviews again. But you will have the pictures, you will have the Facebook data. I think it was mentioned during the direct examination testimony that it's backwards. So if you're trying to look at it, you got to remember that it goes backwards. You got to remember that it's universal time, so you got to subtract 4 hours. But if you really wanted to sit there for a week and just go through the records, you could see all their communication during all these days. And we just showed you a little bit of it, with Investigator Alexander on the stand with Bo Alexander, because we wanted to show you that during this period of time, she's not here with her kids either. He's gone smoking dope over on Woodlawn Road, but he won't tell her where she's at. And then he'll, like, the next day say, come pick me up. Here's the address. Like, after he's partied, after he's done whatever he wants to do, and he needs a ride again in the Methmobile, he, I guess flashes the big M up in the sky, and she comes and picks him up, and they go to the next meth house. And so they go from, Woodlawn, they go over to Laurel Drive, and they stay over there at Laurel Drive with Shane Kidd and his crew, and they're bouncing around in Meadowbrook, et cetera, et cetera. So we know that all this is happening during this period of time of October the 1st through the 3rd. And we know that this child is just in the hands and in the care of Megan Sorrells. Again, thankfully, because there's no suggestion of anything but love and kindness that Megan would have supported that child and tried to do the best that she could to take care of that child. She is a good mother, obviously, to her children, and she was trying to help out. I think she alluded to the fact on the stand that she knew what Cortney was up to, and she didn't want that child to be around that environment. And then on October the 3rd is when Tim comes, and Tim picks up the children and takes them. And we heard the 2 911 calls, and we hear Cortney on the phone, my dad took my kids in my car, and Tim Bell saying, they have abandoned those youngins and that sort of thing. We know that at some point in time on the 5th, Cortney's back over at her dad's house. She calls and asks, will you pick me up and take me to see my kids? And she stays over there. And according to Tim, there's a lot of hollering and arguing back and forth that day. She wanted the car. She's texting Chris McNabb like crazy. Those are a lot of those messages that we were reading to you where, they're fighting, and he's saying, give me the car. Just get the car, steal the car, do this, do that. And that's what's happening on the 5th. Then by the 6th, that's when Tim Bell's going to bring the children back to the house. And so where has Caliyah, by the way, been with her mother? We don't even know where Caliyah was between the 27th and the 1st. There may be a suggestion that Missy Davis was watching them sometimes, but we don't know that the child was even with the parents during these 4 days, but we certainly know that the child was not with the parents between October the 1st and like the 6th. So there's 5 days missing of her life. There's 4 days missing up here, which is 9 days. I mean, the child was missing here. So, they've only had their child for a couple of days. So for either of them, especially when Matt sit there and say, I love my babies. I loved holding her. Oh, I loved, just loving on her. And when I touch on her little face and calm her down, he's just full of it. He's running around chasing dope and chasing his freedom and abandoning his children. He talks like a dog to the mother of his children. Thank goodness Clarissa is not being raised by that man, because what would he have taught Clarissa about how to treat a woman or how to treat the mother or how she should be treated? Tim Bell did a good job raising Cortney to the extent that he could. I know he's a father raising a daughter, but he's indulged her a little too much. He's overindulged her. There's no insult, as Mr. Frost said, about the living in the mobile home park. Nobody's insulting that. They had provisions, but not because they were getting their own provisions. It's because they were letting their grandparents take care of everything, buy them all the milk, buy them all the diapers, even buying them cigarettes. They just literally, Chris McNabb was a user, and he was an abuser. He abused her, being Cortney. He abused drugs, and he used Cortney for a car, and he used all the items at Tim Bell. I'm sure he kept the refrigerator stocked, and he kept food in the house, and he kept diapers on the baby. So that's all credit to Tim Bell. And then the baby is missing, and then the baby is found dead. And really, we know the baby was dead on this day. The baby was dead on the 7th. Baby Caliyah had a very short lifespan. And if you want to sit here and say that Cortney Bell has no responsibility in this, that's just not true. That's the mother of that child. All of those days, from the day she left the hospital, that baby could have been in that trailer. I say nice trailer. It wasn't nice because it was dirty and messy. But Cortney Bell could have been in that trailer or with Tim Bell. She had places to go. You know Kim Weatherford, you know Megan Sorrells, you know they would have let her come over there. She had places to go to take care of that child and do what any mother should want to do with their newborn baby. Cuddle it, hold it, sing to it, pray over it, nurture the child, but she chose to take this baby down this path with her. And she put Chris McNabb and herself above her child. And so therefore, she is negligent because she created this environment. She's the one that night on October the 6th, if we're going to get specific now and not general, she's the one that said, how could you leave without me? I would have smoked dope too. Then she's smoking dope right then, hours before her child goes missing. That's negligence. If it's not, then is it okay if everybody, if you've got a child that's under 2 years old, if you've got a 14-day-old in Covington and you can't afford to go to preschool, just go drop them off at the local Met House in town. No, that's not negligent. That's not abuse of the child, right? Because the minute that happens, pretty sure DFACS is going to take the kids. Pretty sure if my office finds out about it, you're going to get prosecuted. And that should be the message that comes out of this trial. You want to abuse drugs? Then do it. You want to bring children into this world? You better raise them. You better take care of your children. Break the cycle. She failed to provide proper parental care and adequate supervision. I just want to go back for a second because I don't know if you noticed this here, but I got a rattlesnake right up there. When I click on it and it goes into the drugs and all that. And the rattlesnake is because you would never take a rattlesnake and you wouldn't throw it in a trailer of that size with a newborn baby, would you? You wouldn't take a rattlesnake and throw it in with a 14-day-old child and think, but that wasn't careless, that wasn't negligent, was it wanton or willful neglect? Would you put a rattlesnake? What would you expect might happen if you put a rattlesnake in a trailer with a child? That child's going to get bit. Something bad is going to happen. Well, Chris McNabb was a rattlesnake. Chris McNabb was a rattlesnake, and so was the methamphetamine that she put into her body. That's another poisonous venom in our society that she chose to bring around that child. And so you can't get around the fact that Cortney Bell shares in the responsibility of her child's death. Look at her behavior afterwards. Running around, smoking dope. Even when Chris jumps out of the car and she knows her baby's found, she wants to go to Anderson Circle to get high. So in count 3, she's charged with failing to provide proper parental care and adequate supervision. And it says contributing to the deprivation of the minor. The statute actually says contributing to the dependency of a minor. But the body is what is important. What's being alleged here is that she willfully failed to provide parental care or control for Caliyah McNabb, a minor child under the age of 18, and failed to provide such child with adequate supervision necessary for the child's well-being. Said act resulting in her being deprived, or actually, again, substitute the word dependent child in accordance with the provisions of Code Section 1511-2. So Code Section 1511-2 essentially is kind of what's in the body here, that if you're failing to provide proper parental care, or you're making that child in a situation that they're dependent, so as like they need even like the court's protection, then you're contributing to the dependency of that child. And of course, she's got that in her statement, that she knows DFACS could take her children. So she's aware that she's contributing to this, that she's making her child dependent upon protection of the court, and that her child has been abused or neglected. And so all of these sort of are similar when you're talking about her charges are independent. You have to find her guilty of each one, independent of each other. But I would suggest that the evidence has shown in this case that she is guilty of all 3 counts in this indictment because of her actions. Now, quickly, I'll go through the timeline again. I think we've all got these dates and times memorized in our hearts. 3 to 5 a.m. was when they said that they were sleeping. 5:51 is when we know McNabb is on Facebook. 9:33 is when the text message comes in from Dad McNabb. And then we've got Chris texting Cortney Morris at 9:42 in the morning, which, sort of busts his little window down to a very small time frame. Somebody could have broken in and stolen his child. And then Cortney says, we wake up at 10:19. So even if you look at 9:42, if he's texting and flirting with this Cortney Morris, oh, sorry, my bad. Well, one of the reasons why I wanted to play that last jail call that we played with Bo Alexander is he talks about this whole thing with Cortney Morris on there with Cortney Bell. And she's like, Cortney Morris has screenshots of you, communicating. And he says, no. Remember that night before you told me to block her? So you get the idea, or you get the picture that Cortney Bell discovers that he's on Facebook, sending in a friend request or a message request to go talk to Cortney Morris, who he's never met before. But remember, he's loving his babies and having a regular family day of living, according to his statement. He's sitting there flirting with some woman at 8 o'clock at night on the night before. Cortney tells him, shut it down. You don't need to be talking to her. You need to block her. And then he unblocks her the following day. So he admits that. He admits that sin. He can't say somebody hacked into his phone and it was somebody else. He admits that he was the one that was texting her. That's in the jail call. And he admits that Cortney had told him to block her the night before. And then he tries to play cool to the girl the next day. The other Cortney, like, oh, my bad. I don't know what happened. You can't say, like, my girlfriend caught me and she made me block you. He would lose cool points if he did that. So he has to act like he accidentally blocked her. But if he was awake enough to do that, do any of y'all believe that he fell back to sleep then before little Clarissa comes in there? And Clarissa comes in there at around 10:19 in the morning. And incidentally, it's very important about what Clarissa did. Because if a child had seen something or heard something that concerned her, you would think that she would go running to the arms of her parents because she was in need of protection, or she was hurt, or she was scared, or she was frightened. But she was hiding behind that couch. They both said that she was backing up and hiding behind the couch. Would that not be suggestive of the fact that one of the two of them were involved in whatever happened to the sister? Why would she hide from her own parents? Pretty powerful evidence, her body language. She was only 2 years old. He even makes a statement like, Daddy's a protector. Daddy can't even protect their mother from himself. And then we have the 911 call. Then Chris, of course, does a disappearing act, which he's known to do. Remember, he ran even from the hospital when his own baby was sitting there because he got freaked out and saw the police. And Shane Kidd said he had to go pick him up because he ran from the hospital and goes into Academy Springs Park, which I'm not really clear why that would be a good place to go because that's right across from the police department. I'm not going to go through the calendar again because we just did that a little bit ago. I want to finish up by just talking about the law. You've heard reasonable doubt read to you a couple of times, so I'm not going to reread it. But I do want you to know and remember that it's not a vague or an arbitrary doubt. So it's not just, well, they didn't account for the escapee. They didn't account for the person who might have broken into the house, the conspiracy theories and all that silly nonsense. The state's not required to prove that, to disprove every theoretical that they can come up with. Nothing else makes sense in this case. And we've proven to you beyond a reasonable doubt the elements of the crime against Mr. McNabb. In fact, Mr. McNabb is charged with malice murder. So I want to talk for just a second to you about what he's charged with, because those charges are different than Cortney's. Now, Cortney is charged with cruelty, and so is he. And we talked about that. The same principles of the law apply. It was argued by Mr. Frost that if you don't believe that Chris killed the baby, then Cortney is automatically not guilty. So in other words, if you don't think that Chris McNabb is the one who killed the child, and you think maybe somebody else broke in and took the child and killed the child, then she's automatically not guilty. And that's just not true. Because as a mother, she's there to protect her child for whatever is happening, whether it's McNabb or whether it's random stranger guy. And it's not as if she was just a mother, again, doing what's right, being alert, being ready to take care of her child. She had smoked drugs, and that's made her incapacitated, if you will, to be able to protect her child. So she's guilty, even if you don't think that Chris is the one who murdered the child, although I would argue that Chris murdered the child, of course. Malice murder. A person commits malice murder when that person unlawfully and with malice aforethought, either express or implied, causes the death of another human being. Express malice is the deliberate intention to take away the life of another, which we don't have here. That would be like somebody saying, hey, I'm going to kill my child. Don't have that in most murder cases, but you have implied malice. And implied malice is when all of the circumstances of the killing show an abandoned and malignant heart, which is what we have here, right? The circumstantial evidence, the circumstances of those injuries to that child suggests that whoever killed that child had an abandoned and malignant heart. You'd have to kill a 14-day-old baby. You'd have to, especially to be the father of that child. And so it's for you to decide whether or not the facts and circumstances of this case show malice. But it doesn't mean that it has to be a premeditated murder. It doesn't mean that there has to be ill will or hatred towards the child, but it's the unlawful intention to kill without any sort of justification, excuse, or mitigation. So you don't have to premeditate it. You don't have to have motive. And you don't have to have any sort of period of time, like a planning period of time. If a killing is done with malice, no matter how short that time of malicious intent may have existed, such killing constitutes murder. What that means is if he's sitting there playing video games or he's playing on his Facebook or he's smoking meth, doing whatever he's doing, like Courtney's passed out on the couch, and he hears that child crying one more time and it drives him crazy, and he goes back there and he does whatever he does, that's malice murder. You don't have to have a plan. You don't have to say, well, I think I'm going to go back there and kill my daughter right now. Because we know McNabb, what we know by all of the things we've seen in this case, he's impulsive. He doesn't think before he acts. He punches. He slams his hand against his fist against that table. He loses it on the phone. He screams. He throws things out the window. So that's still malice murder because there's no time frame for which he would have had to form that malicious intent. He can form it in an instant. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. So he literally could have thought in 2 seconds, he could have gone back there, picked up the baby and thought, well, maybe I'll feed her and she'll shut up. And then when he put that bottle in her mouth and she wouldn't shut up, he just, no. Whatever he did, however he killed that child, that's malice murder. It can be formed in an instance. It doesn't have to be premeditated. And we do not have to have motive as well. There's no motive that's required under Georgia law. Certainly the motive in this case would be that he is just an angry, agitated person when he's on methamphetamine. In fact, Craig Weatherford testified that everybody acts out of character when you're on methamphetamine. And we know the defendant said that several times in his statement. In the third statement, on the 1213 statement, he's telling Alexander that he beats Courtney up. And he's like, man, it was a meth. I was strung out on dope. And that's sort of his excuse for why he's so violent towards Courtney is because of that. Now, he's also charged with felony murder. And a person, in this case, we've got two different crimes. Felony murder in Georgia law is just an alternative form of murder. So you've got malice murder, right? He's guilty of malice murder because it's not that he formed the intent to kill that child in an instant. And the circumstances surrounding the amount of blows, the extent of the damage shows that there was a malice intent, which is not ill will or hatred, but an intent to kill. He formed that. He's guilty of malice murder, but felony murder would be, in this case, killing the child in the commission of the aggravated battery, which is what he's alleged to have done, and also in connection with cruelty to children in the first degree. So you've heard cruelty second. What's cruelty first? Well, first of all, he's charged with aggravated battery. Everybody knows what a battery is, right? A battery is when you punch somebody, and an aggravated battery is probably just what it sounds like. It's when it's a really bad battery. It's when you maliciously cause bodily harm to another person, in this case, Caliyah McNabb, by rendering a part of their body useless, a member of their body useless. In this case, Caliyah McNabb's little brain was useless, right? Because we saw what it was liquefied. And said Caliyah McNabb is the child of the accused. So she is his daughter, of course. And in this case, it's alleged that he maliciously caused bodily harm. So if in the maliciousness, in the act of causing the harm to the child, which rendered the child's body useless in some part of their body, which in this case we've alleged the brain, the child dies, that's felony murder. So it's just when you're committing a felony and there's a cause relationship, that felony causes a death. And so here, he's guilty of aggravated battery, just like he's guilty of malice murder. And because he's guilty of aggravated battery, then he's also guilty of felony murder. Each of these are alleged both in the felony murder, but also independently, if that makes sense. So you can't have a felony murder without having felony. All right, and then he's charged with felony murder in connection with cruelty to children in the first degree, which is that he maliciously caused Caliyah McNabb, a child under the age of 18, cruel and excessive physical pain by inflicting blunt force trauma upon the child to her head. Again, it's kind of one of those, either but you believe he did it, if he didn't. If you believe that McNabb was the one who killed that child, he's guilty of all these charges. They're not difficult charges legally, as Mr. Carter said. It's that, again, he caused excessive physical pain by inflicting blunt force trauma upon the child, which is different than cruelty in the second, which is what we've got both of them charged with, where there's criminal negligence. So remember that cruelty in the second degree just means it's negligence. That's why Cortney's charged with negligence. She's not charged with murder, malice murder, felony murder. She's charged with murder in the second and cruelty in the second. And cruelty in the second is what forms the basis of the murder in the second. In this case, he's charged with cruelty in the second as well, with criminal negligence. Again, same exact charge that Cortney's charged with. Now, Mr. Carter says, well, there's no evidence of that. I can't imagine a scenario where a TV fell on the child. And I would contend that there's really not any evidence that a TV fell on the child or that anything bad happened and he tried to cover it up because the injuries are just so bad. You know, they're crushing, and everything that Dr. Darrisaw testified to is not really consistent with just even a bad accident that happened to the child. He also would be a fool to have not have told law enforcement that, because he would have a much lesser degree of culpability if that had been the case. But he would still be guilty of second degree negligence if one of his meth head guys that had some sort of a beef with him broke into the trailer and killed his child. I mean, you can find that if you believe that it's negligent. See, negligence is really a jury question, right? Because the defense is saying, well, I mean, not every person who does drugs and, should be charged with negligence or neglect, but you're looking at it in this case with these circumstances. A different jury with different circumstances might find that somebody wasn't negligent. So it's very fact dependent, and you, the jurors, are the ones who determine whether or not they were negligent. And if you do believe somebody snuck into the trailer and killed his child, whether he should be found guilty just like her because they were smoking meth and asleep. I would suggest in this case there was no sleeping on his part, and so he's guilty of these other murders and the cruelty in the second. Because it's negligence, he's not. But it's kind of like, if he's guilty of all these murders, that one just stacks underneath it. So if you were to find him guilty of every count in the indictment, they'll end up merging. The judge would do that as a matter of law. So you don't have to sort through that. Like, well, if we think that he killed her intentionally, what does it mean? You have to find him guilty on every count. But that doesn't mean that he's going to be sentenced for 5 different murders, if that makes sense. And you're going to have a jury verdict form just like this for each defendant. And whoever you select to be your foreperson will, of course, after you deliberate, fill this form out. And you would say, we, the jury, find the defendant. And you'll fill in this blank, either guilty or not guilty, for each and every one of the counts in this case. Now, he's also charged with something different that she's not charged with. He's charged with concealing the death of another, because we know that whoever killed this child, and of course the evidence suggests it was him, took the child out into the woods and concealed the child. You saw that hole, and you know that the person, Miss Tara Robinson, who discovered the bag that the child was in, actually found it covered with debris. So there was an effort made to conceal the death of another. Unfortunately, it was the death of his own child. I told you I was going to wrap up by explaining just a couple more principles of law. Direct and circumstantial evidence. In considering the evidence in this case, you may use reasoning and common sense to make deductions and reach conclusions. And you should not be concerned about whether the evidence is direct or circumstantial. The judges can explain to you the difference between the two, but circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, by consistency with some fact or the elimination of others. But the important thing to remember about this charge is that you don't have to be concerned about whether the evidence is direct or circumstantial. They carry the same weight. And lastly, as a principle of law, I'd like to talk to you just about voluntary intoxication. Georgia law provides that being under the influence of drugs shall never be an excuse for any criminal act. It further provides that if a person's mind, when not affected by drugs, is capable of distinguishing between right and wrong, as well as reasoning and acting rationally, and the person voluntarily deprives themselves of that good reasoning, that good judgment, then because they have injected those drugs and they committed a criminal act, they're going to be responsible just as if they were sober. So you can't just be sober and know, like, it's probably not a good idea to have meth in the house with the kids. I'm going to stop that. As soon as Chris puts a wedding ring on me, as soon as he starts, stops beating up on me, we'll have that happy family. And then you get high on meth. I mean, you know the difference between right and wrong. Both of them do. He doesn't run because he's scared. He runs because he's conscious of that's called consciousness of guilt. He runs because he is conscious of his guilt. He knows it. That's why he runs. Each verdict form is separate. I hate to bring up any photographs from the child's autopsy.
Get off that,
really
cameraman.
Post-incision autopsy photographs displayed here. I wouldn't do that to Caliyah, and I wouldn't do that to you again. And I really respect the family that's in here as well. But I find it very ironic. The child was wearing a shirt that said "Stay away, boys," and I say a shirt, a little onesie. My daddy works out. That father who this shirt essentially speaks to what every little girl wants from their dad. They want protection. They want a man they can look up to. They want a person who respects and protects their mother. I've always heard it said the best way you can teach your children to love is to show and love their mother from a man. And he didn't do any of that. He was so abusive. He was so selfish. And he really harmed that child before he took these malicious, horrific, appalling acts of violence against her. He harmed her, by the way, he deprived her of her mother, searching and following around Covington for him. This case is about a cry for her innocence. I can't think of anything more innocent than these little feet and that little thumb that was printed on her body, or from her body, on September the 23rd. Those little feet could have taken her somewhere in life. She had a long life ahead of her, and she was deprived of that life. And even though she only weighed a little over 6 pounds, her life was valuable. And under the law, she is a human being. And under the law, she is entitled to all of the same rights that he is, that she is, that all of us are. This case is about crying out for her. I literally can't not think about, and you shouldn't be able to get out of your mind, the cries of that child that night. He suggests in his last statement that whoever killed her, maybe she just cried really loud. That was a Freudian slip. That child cried and didn't do anything but need love and need support. And her daddy killed her because of that. And so not only does that child cry, did she cry that night, we cry as a community, the citizens of this county, Newton County, we mourn the death of Caliyah. We cry out for justice for Caliyah, and we cry for a verdict of guilty on each count of both of their indictments. Thank you.
Y'all give me some guidance. I can either do the closing charge and then I'll send you back.
Well, if I could, I would give that lady a standing ovation. Well said, well done, well put together. She's very well spoken. She was very fluent, like she didn't take breaks. She's not like me. I'm more like that defense attorney. I get distracted, but she did great. She did a good job of tying it all together. That was amazing. Like, yeah, she did. She did a really, really good job. I can't say it enough. She did very well. And she does, whoop. And yeah, I mean, you guys obviously We liked her better than the defense in this case. But the way she kept staring him down when she would say something was like, oh, I don't know. I think she was doing it on purpose and like, hey, look, I'm a woman. I'm going to tell you now because you like to beat women. So here's one that has more power than you do right at the moment. And I kind of wonder if she wanted to kind of get elicit a reaction from him, just to show the jury, yeah, he's a hothead. He gets angry very easy. And I was looking at the people behind, which I think is family, and I'm just going, what do you guys think? I don't know that I'd be sitting on that side. I think I'd be sitting on the other side. I don't think I'd be sitting behind you. I mean, maybe if you're my kid, but yikes. All righty. We're going to go up to the verdict. Let me make sure. I don't want to do jury instructions if you guys are all okay with that. So I think this is what this is, but let me just make sure.
These are two separate cases against each defendant. You'll have out two different verdicts.
Oh, yeah. No doubt about it. And I wish that she could have, and I know she doesn't know. It would have been because she kept saying they passed out because of they smoked meth and then passed out. But like meth does not, as far as I know, make you pass out. Isn't the meth keeps you up all day or 4 days, as you see some people. And I wish she could have said they were smoking meth for 3 days before this happened, or the whole time that Caliyah wasn't with them, so that they had been up for days. And I wish she could have put that out there. I know she just doesn't know. So, but it just would have tied that even in a neater little bow. Thank you, Adair. I appreciate that. I am trying. I hope we get some good attorneys in the Adam Montgomery case too, because it just makes it all better. At least get good prosecutor, good defense, presenting good cases, and it wasn't much for the defense to present in this one. Let me fast forward here. And is meth the one that they get all twitchy? Like from if you're watching the police that talk to them on stop them on the street or whatever, and they're all twitching, they can't sit still and they can't stand. It's just all these involuntary movements. Yes, he does, Gabrielle. So regardless if he gets convicted of this crime against his daughter, and then maybe we can do something that's not a child. Maybe. Yeah, he's in jail already. So prison. But so yeah, meth is weird. These guys up here in this front row with all their little sheriff's badges or whatever they are, they look like they're very young. Sarah Boone just lost her 7th attorney. So I'm beginning. She's got a new judge. Her 7th attorney is out. I don't know. I don't know when Sarah Boone is coming up, if ever. So Sarah Boone she could spend the rest of her life in jail just trying to come to trial. Yes. I was thinking more of the people when you're talking. I can't explain, I can't do it, but there's it's a certain twitchiness that I have seen on people when they're clearly on something more than alcohol. But uh, yeah, I need to look up to see if that is going to start because the judge recused himself, and rumor is that the prosecutors are going to kind of quietly just walk away, but I haven't seen anything yet. All right, here we go.
Okay, I understand they have arrived at a verdict. Does the state wish to receive the verdict or wish the court to publish the verdict?
Let the court publish it.
Okay. Bailiffs, when they come out, we ascertain who the foreperson is. I want you to bring the verdicts to me. Okay? Anything else?
Yes, sir.
As always, I don't want any outburst in my courtroom. So if anybody, I want you to think what it'd be like if the verdict's against what you want. If you need to leave, go ahead and leave now.
And don't leave
Nobody's
after the
leaving,
verdict.
so I think we're ready. Bring the jurors in.
I have an update for you, at least on this one. I don't have updates on the other one, but yeah, I saw it back to Sarah Boone. I was watching The Lawyer You Know, and he said they will not deny her representation. So I don't know, but her last judge said to her, "You don't just keep going." So I don't know if at some point she would have to get her own. I'm not sure. She didn't have any money. She's been in jail for what, 4 years now?
We're waiting on the alternate jurors, but y'all may be seated if you're more comfortable seated.
You were waiting on me. Said he was waiting on the alternate juror. Sorry, I just can't resist. One last ceiling check.
Okay, everybody may be seated. Mr. Foreperson, I understand you have arrived at a unanimous verdict on all counts on both indictments. Is that correct? If you'll hand it to the bailiff seated right here, he'll bring it to me and I'll publish it in open court. Each verdict form reads, in each of the counts against each defendant, we, the jury, find the defendant guilty. That's all 3 counts against Ms. Bell and all 8 counts against Mr. McNabb. Is there anything further required of the jury?
Yes, Your Honor, that's what you told the jury.
Okay. Except for the alternate jurors where you don't have to answer. I'm going to start with the jury foreperson. I'm going to go down to you. Then I'm going to skip back to the second row, go this way, and then I'm going to skip back to the third row and finish up. Except for the alternate jurors, y'all don't answer. Mr. Foreperson, is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into? Was it freely and voluntarily entered
Oh,
into?
yes, sir. Yes, sir.
Is this your verdict?
Yes,
Is it a true verdict?
yes,
Was it freely and voluntarily entered into?
yes,
Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes.
Is this your verdict?
yes,
Is it a true verdict? Was it freely and voluntarily entered into? Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes,
Is
sir.
it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict? Is it a true verdict? Was it freely and voluntarily entered into? Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
yes,
Was it a true verdict?
yes,
Was it freely and voluntarily entered into?
yes,
Is this your verdict?
yes,
Was it a true verdict? Was it freely and voluntarily entered into? Is this your verdict? Was it a true verdict? Was it freely and voluntarily entered into? Anything further required?
Yes, Your Honor.
If y'all, all of the attorneys come forward and look at these verdicts to see that they're in its proper form. each is dated and signed by the foreperson.
Here's me,
Mr. Frost?
Yes, sir.
I order that be filed with the court.
Yes, all counts.
Ladies and gentlemen of the jury, I certainly do appreciate your service. A difficult case, very emotional case. I always want to thank the alternate jurors who had to sit through the case without the deliberation phase of it. I really do appreciate your effort. I'm going to go ahead and excuse y'all, so I'll excuse you. Now we have the media around, whether y'all talk to media or not talk to media, that's up to y'all. You understand it clearly. Nobody can make you and nobody can prevent you. Is that clear to everybody? Okay, you excuse me for the attendance on the court. Thank you.
So I think they sentence. Roseanne, I plan on doing Paul's sentencing. I think it's on the 26th, I think. So we may have to cut out of the Montgomery trial if it's still going, then come back after everything that I've kind of seen on my the comments. I don't
Need
really
to
care what the
calm
judge
down.
gives him if all that is true.
You said it 5 times. Let's take Mr. McNabb out of the courtroom.
All right, sorry, I was talking. What did we miss?
Calm down. Need you to calm down. You said it 5 times. Let's take Mr. McNabb out of the courtroom.
So he can't keep his mouth shut. You're welcome, Roseanne. So like I said, I'll get it covered one way or the other. I need to check because I keep moving crap. Wonder if she wanted to go too. All right, Judge, what are we doing? Don't worry. If they don't sentence them, I know what they are. And then because I didn't, some like Florida sentences a lot on the same day, especially if it's this kind of a conviction. For him, there's only one. And I don't know, you get life. I don't know what, holy cow, is that the jurors leaving? I bet jailers had their hands full too. Is that at the end of this? Because I couldn't find it anywhere. Yeah, I think that was the jurors.
Y'all all be seated.
I hope they're being sentenced right now.
I'm going to have
Maybe.
the defendants brought out one at a time to go to sentencing.
Yep, here we go.
Sentencing here. Mr. McNabb is going to be placed, of course, in cuffs. Oh, I'm not going to, when I say I'm not going to tolerate outbursts, I don't know. Nobody has control over Mr. McNabb, Mr. Card. I don't believe you've got any control over him either. But if, in fact, I can't talk to him in any kind of way, and he continues with these outbursts, well, we got it live streamed. I'm going to put him back in the back room with a computer or something. That's why I called you out, to see if we've got any ability. If anybody's got a computer or a laptop, And if you have somebody from your office that you would want to come sit with him, I need to know that, and you need to get them on up here. But I'm gonna give him a chance first to see if he'll behave out here before I get into that. So I'm gonna let you go make a phone call. Do you want to get somebody up here in case we have to send them back?
Mr. Hall's here.
Okay, then that'd be sufficient. Okay. My next question is, do we have the ability to live stream back there? You say no. I just meant there, do we have, I don't know. I've got all these brains out here. Y'all tell me something.
Like, right, it probably wouldn't be high-tech live streaming. It would be more like FaceTiming or something.
FaceTime.
That's the best I could come up
I
with.
could pull up my phone right now and pull up Court TV, for instance. They're live streaming the thing. You
Right.
can see it on your phone. There's no, you could do it on a computer if you had the computer and you had the Court TV, if you had the app for the Covington Facebook page, which you could get up on a laptop, and then just, sit there and they'd see the whole thing.
Right.
What do you suggest, Mr. Carter? Would it do any good for you to go back there and talk to him?
It would go.
Why don't you go back and talk to him while I sit out here and you tell me after you've talked to him? Or whether you got some kind of assurance. Well, that's the worst. That's what we'll do. Yeah. I'm about to the point of where to say,
The judge, he said, I'm about to the point of saying, well, hell, just leave the door open. So I think so he can hear. I've never heard them say that in a positive way about pulling up Court TV. All right, I don't know how long that goes on. Whoops. Because the judge always gives the defendant a chance to speak. Oh, he's going to take it.
we've had a kind of a preliminary discussion back in my chambers on Wednesday morning about this. I'm going to direct both the state and Mr. Carter. The court will sentence on malice murder. By law, counts 2 and 3 of felony murder are vacated. Murder in the second degree would merge. I've been told that the aggravated battery merges also. That cruelty to the children in the first and the second degree are all about the blunt force trauma. So each of those merges into count 1. And finally, count 8, concealing the death of another, you have to be sentenced on that too. Is that 10-year sentence?
Yes.
Okay. Is everybody ready? Bring out Mr. McNabb. Are y'all ready for the sentencing hearing?
I dare he just had it. All the verdict form was down and condensed, and it was guilty across all 9 counts. He didn't read each count.
You may be seated, Mr. McNabb. Let's turn to the sentencing hearing. And does the
Absolutely.
state have anything it wishes to offer in the way of aggravation?
Yes, Your Honor. We have several certified copies of convictions as well as one witness that I believe is on her way here in the courthouse. The first would be State Exhibit number 137, which is a certified adjudication order from juvenile court, case number 107-01J-0625 and 107-01J-0611. That is for disorderly conduct, where the defendant was adjudicated delinquent for that offense as a juvenile in June of 2001. State's Exhibit number 138 is also an adjudication order for case number 1007-00J-1281 and 1354, where the defendant was adjudicated delinquent for simple battery as a juvenile in January of 2001. Also case number 10799J702. This is State's Exhibit 139, which is an adjudication order from juvenile court for simple battery from November of 1999. We also have a Superior Court conviction out of the Superior Court of Bartow County. The defendant was convicted in Bartow County for theft by taking, entering a motor vehicle to commit a theft, criminal damage to property, burglary. He was sentenced on case number 2007-1989. And that was in October of 2007. That's State's Exhibit number 140. State's Exhibit number 141 is a criminal conviction for the Superior Court of Newton County, case number 2013 CR 1263-5. The defendant was convicted of theft by shoplifting and giving false information to a police officer. He was adjudicated guilty or sentenced on this particular case in the October term of 2013, and that's again State's number 141. Also State's number 142, which is a Superior Court of Newton County conviction on case number 2015 CR 02-5, where the defendant was convicted of obstruction of an officer. That again was a sentence from the January term of 2015. The state offers State's Exhibit number 143, which is the Superior Court conviction out of the Griffin Judicial Circuit, where the defendant, Christopher Michael McNabb, was convicted of obstructing and hindering a law enforcement officer felony, driving while license is suspended, driving on the wrong side of the roadway, speeding, stop sign violation, and failure to maintain lane.
I
And
saw
that
that.
was in August of 2001. State offers Exhibit number 144, which is a conviction out of Coweta County on case number 2013-0190. And there, the defendant was convicted of one count of theft by taking, and that was in, looks like February of 2003. These are all certified copies of convictions that the state has for Christopher Michael McNabb, and I'm showing them to Mr. Carter now.
Judge, I have
Not the
objection
kind he wants to
Exhibits
do.
140 through 144. I do object to the misdemeanor juvenile delinquent, juvenile adjudications.
Judge, I know the law is clear that anything can be used in aggravation, so juvenile adjudications are admissible. I have one witness.
Well, let me finish with this first, Ms. Zahn. I'm going to admit everything into evidence. If it makes any difference to you, the misdemeanors mean nothing to me, Mr. Carter. And I would not enhance sentencing at all because of the misdemeanors. Now, Ms. Zahn,
Your Honor, the state calls Priscilla Faulkner, Dr. Priscilla Faulkner. Could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give in the matter now pending before this court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you. Please state your name.
Priscilla Faulkner.
And you are a doctor?
I am.
And a doctor of what?
Psychology.
I want to draw your attention back to October the 14th of 2017. Did you have the occasion to go to the Newton County Detention Center to have contact with Christopher Michael McNabb?
I did.
What was the nature of that contact?
Your Honor, I'm going to object because the notice of this aggravation was only provided to me last night.
why is that a concern?
Because it should have been provided prior to trial, and it was only provided last night.
Ms. Zahn?
Well, Judge, I learned of it yesterday, and I reached out to Dr. Faulkner and spoke with her to confirm the veracity of this. I let Mr. Carter know last night, and Mr. Carter notified me this morning that he was already aware of this. So he's known about this. There's no prejudice or harm because he's known.
Is that correct, Mr. Carter?
I was aware of the situation. I was not aware that it was intended to be used as aggravation.
I'm going to allow the testimony.
Okay. What was the nature of your contact with Mr. McNabb?
I was evaluating him at the request of Newton DFACS.
And did you have the occasion to be working on your computer down there at the jail while you were talking to him?
I did.
And at some point in time, did Mr. McNabb tell you to look up?
He did.
And when you looked, where was he at in relation to you?
He was probably an inch or two away from the glass, right in front of my face.
So were you separated by glass?
We were separated by glass.
And what did you see when he asked you to look?
He was wearing a turtle suit, which is something that prisoners are wearing when they're on suicide risk. And he wasn't wearing clothing under that, and he had pulled up the turtle suit and taken out his penis and was masturbating.
Did he
Ow.
masturbate to completion in your presence?
He did.
Thank you. Those are all the questions that I have.
No question, Joe.
I got a question. Can I address the court, please? I just got one thing I want to say, and that's it.
Excuse you for a
I'd like to say it in front of her since she's the one accusing me.
Talk when your time comes. And at the time, you can say anything you want to. Is there any further evidence in offering of aggravation?
No, Judge.
Mr. Carter, do you have any evidence to offer in the way of mitigation?
I believe Mr. McNabb would like to address the court.
Okay, you may do so. You may stand up and address the court.
I'd just like the court to know, as well as everybody at home, since this is being broadcasted for whatever reasons, that I did have on a turtle suit and it velcros and it wasn't on properly and it didn't fit properly, and the velcros were not on good because they don't stick, because they've been used for so many years by so many different people, and I was not masturbating at all in front of her, period. The thing fell off when I stood up, and that was it. There was none of that. And I would have liked to have told her that, since she was the one making the accusation, since I'm pretty sure by the law states that I have a right to confront my witnesses who accuse me of doing wrong. So I felt like I wanted to say it in front of her, since she was the one up here slandering me. And that's all I got to say.
You sure you don't want to talk about the sentencing and all of that? That was the only thing you wanted to tell the court?
I mean, I haven't heard anything about a sentence. I was just
About the sentence
commenting on that. I
for the
understand that.
charges. And I just wanted to know if you had anything you wanted to say to the court.
I mean, I got a lot to say. I got a lot to say, but I'm not going to be able to say half of it.
I don't know, because I don't know what you're going to say.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time. I feel like there was things that were allowed to be said that should have never been allowed to be said, that didn't have nothing whatsoever to do with the case and what was being said. Just because somebody has domestic abuse issues with their spouse doesn't mean that they would put their hands on their kids, which has also been pretty much proved that I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids. So that doesn't make sense either. And, just to let the record show that I don't think I ever put my hands on her in front of those kids. And I just don't feel like just because somebody has domestic issues with the female in their life that they love, that they were just able to just say, oh, he don't love you and all that stuff just in front of everybody or whatever, which doesn't matter. But I just don't understand how you find somebody guilty of doing something to a 15-day-old baby, because there was no evidence whatsoever that proved anything about me putting my hands on my kids. I've never done it. I never would. I don't believe in it. I was beat as a child, and I don't agree with it at all. And I would never do it. I would never do this. That's all I got to say. I would never do it. I'm innocent.
Well, I can make a
I didn't think my husband's never had to say anything about putting his hands on me ever. Like, you should say, I've never put my hands on her, period. Not in front of my kids should not be the end of that sentence. That's disgusting. And also, I'm pretty sure that woman knows if you just fell out of your turtle suit or if you were doing something else. There's a difference. Oh my gosh. He's infuriating. I can't even say it. Yes, blackening someone's eye apparently is love. And it was pretty black, so he must love her a lot. Oh, that's disgusting.
a lot of comments on what you said. I can make a lot of comments on the trial, but I know that was just be arguing with you or talking with you. I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
If you ever find out who did them, they deserve to be under the jail.
Okay, so they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement, consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
I want to advise you that you have 30 days after today to file a notice of appeal
It'll be filed.
on this case. I'm going to instruct Mr. Carter on behalf of you to file a motion for new trial to make sure your rights are protected. If you wish to allege that Mr. Carter did not do an effective job, then we'll bring in another attorney to handle the appeal, so that issue can be raised, and that's fine with Mr. Carter. He takes no offense.
I think he
with that.
did an incredible job.
Well, that's fine. I'm just indicating to you that in order to claim your attorney at trial was ineffective or did not do a good job, you have to raise it at the earliest moment, which would be here.
I won't be filing anything against my attorney.
That's fine.
He doesn't
I
need your
also want to
response, sir.
inform you that if the case is appealed, if the Supreme Court of Georgia affirms your case, you have 4 years from that date. The affirmation is made in what they call a remitter. The case is sent back down here to file what is known as a writ of habeas corpus, claiming that your body is still being held illegally and unconstitutional. It has to be done within 4 years of that date. 4 years and 1 day, they would not listen to it. So do you understand that right also?
Yes, sir.
Any further rights I need to advise from anybody that you know about?
No, sir.
Okay, take Mr. McNabb on back.
Later. You nasty. He could have turned around, I guess, and addressed that woman. She was sitting right behind him, wiping tears from her eyes. After his little outburst there, I'm kind of with the prosecutor. I think all those were fake tears. And I hope he finds a spot under the jail. Figuratively speaking, I would never advocate for violent YouTube.
Let's bring her out.
All right, here we go for her. I know they made him be cuffed. It sounds like maybe they did her too. Yep.
Let's turn now to a sentencing hearing on Ms. Bell. Does the state have any evidence it wishes to offer in aggravation?
No, Your Honor.
Mr. Carter, or excuse me, Mr. Frost, do you have any evidence you wish to order in mitigation?
Judge, I would just like to state that Miss Bell's crimes, as found by the jury to be guilty, were more of her being a willing victim, and that spilled over into what happened as to her children. It's terrible, and it's extremely sad that that happened. But I don't think that, and obviously she was not charged to the level that Mr. McNabb was. And I would just ask the court to take those factors. She didn't have the opportunity of having an upbringing, as I think I discussed in my closing. She had no role models for that. She was suffering from addiction and abuse. And should she have done something? Yes, she should have. She didn't, and that's what led her here. And but I think that there's through courses, coping mechanisms, things that she might learn through prison classes and afterwards, there would certainly be the possibility of her being someone who could be a productive member of society if she were to embrace some of those things and put them to use in her life. So we would ask the court to take those into consideration. Thank you.
Does your client wish to make any statements?
I didn't do this. Y'all know I didn't do this.
Ms. Bell, you and I had a conversation back.
We did.
back in chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you think. I explained to you exactly why you were being charged with the crimes. It wasn't that you knew about the murder. It wasn't that you anticipated the murder. It wasn't that you planned the murder. Any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNabb to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put into there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying your child's dead from a rattlesnake bite. Why would you put it in there? And you responded, well, I just wanted her to enjoy nature, have an appreciation of the outdoors without appreciating the danger. I'm sorry, but for you to go around chasing McNabb, doing meth, flies in the face of what any normal mother would do. We hear stories out in society, I mean, out everywhere. The mother bear, they're so ferocious. Why? Because you're messing with their child. All those kind of things. And you chose methamphetamine and McNabb over a baby.
It's a sickness, but I tried to be a good mama. I love my babies.
The problem, Miss McNabb, is that like most criminals, you have this version of what a good mama is that is so far from the norm that, you know, you go anywhere in this county, talk to anybody who's watching this and say, is it a good mama who doesn't even care about her 14-year-old baby? Put them with a cousin. I've known of instances where mamas won't even let in the first couple of weeks of a child's life people around the child for fear that the child's immune system hadn't been built up and they don't want germs brought into the child. They go to that extent. You went just the exact opposite direction. And there's just no excuse for that. On count, well, let's talk about this. Count 2 merges with count 1.
Yes, Judge.
What's the thought about count 3?
I think it's fine, Judge. It does not merge.
Okay. On count 1, I'm going to sentence you with 30 years, with the first 15 years to be served in confinement in the state penitentiary, the remaining time on probation. On count 3, I'm going to sentence you to 10 years in confinement and run at the same time as count 1. Now, do you understand your 2 sentences? Let the record reflect she's nodding her head slightly yes. And Ms. Bell, I'm going to give you the following rights that you have. Within 30 days, you have a right to appeal this case to the appellate level. You may start that process with a motion for new trial, which I'm going to direct the attorneys to file, just a skeleton general motion.
Yes, sir.
If at the time you decide, Ms. Bell, you can allege that your attorneys did an ineffective job. They just didn't do a good job. It has to be brought up at its earliest moment. The attorneys do not get their feelings hurt if you choose to do that. And we would appoint a conflict attorney to come in and take over the appeal. Do you understand me clearly about that? I need you to stand up first off. I need you to start verbalizing.
I understand.
Okay, because she's making a record on all this. It all has to be taken down. I'm also going to advise you that if the case is appealed to the appellate level and the appellate level affirms that case in the verdict and sends it back down for the service of the sentence, you have 4 years from the date it comes back down to file what is known as a writ of habeas corpus. That means I'm being illegally detained unconstitutionally, and I want my body out of jail. But it has to be done. It's a time-sensitive thing, and you only have 4 years to do that. You understand that clearly?
Yes, sir.
Yeah, do you have any other questions? Okay, take her on. Yes, ma'am.
max on count 3 is 5 in confinement, Judge?
Is it 5?
Yes, sir.
Then it would be 5. Whatever the max sentence is, it'd be 5 years
Correct.
confinement, concurrent. Okay, you may take her on back.
Yes.
So she got 30, has to serve 15, and 15 on probation. All the sentences will run concurrent. They'll run together. But wait, there's more. And if you know what it is, don't
Is there any-
tell. Don't tell. Because you're either going to be, I don't know. I don't know how you're going to feel about it because I don't know how I feel about it. So let me find my cursor because that's important. Obviously, so this happened, they were sent, May 2019 was when they were found guilty, both of them, and sentenced. They appeal, both of them. One got upheld. The other did not. So his got upheld. He's life. Hers, on the other hand, let me get to it. So she appealed, and in February of 22, the appellate court reversed 2 of the charges. So she was convicted of second-degree unaliving, second-degree child cruelty, and then contributing to the dependency of a child. In 2022, the appellate court overturned the second-degree unaliving and the second-degree child cruelty. So, which meant then now she wasn't going to have to serve as long. In April 2023, they appeal the rest of her sentence. In October of 23, the appellate court overturned her last charge. They overturned everything. I have not found where she's been released. I assume she's been released. The state said on the day that the ruling came down for the first one in 22, that they weren't sure if they were going to retry it or not. And I haven't found anything about if they're going to retry her at all or not. So I have just a little blurb of what the appellate court sent back and said. I was shocked. Absolutely. All right, why is my page not showing up? Hang on a second. I believe that she is out. I don't know why she wouldn't be out. Hang on, this video is going to start even though I don't want it to. I haven't found where they've released her, but I don't know how they I don't know how they wouldn't have released her. You might share this is the right one because all right, I think I've got the right one. Yeah, she got everything overturned on appeal. Oh, you know what? This page, there we go. I was gonna say, funny, because I was trying to do it earlier. So the Georgia Supreme Court ruling exonerated any reasonable expectation of responsibility for Bell and her daughter's death. So they say the evidence here showed that Bell went to sleep one night, checked on Caliyah early in the next morning, and went back to sleep for 4.5 hours. The evidence further showed that while Bell slept, hang on, let me take myself out of the way. McNabb committed a violent crime that the state conceded was the direct and immediate cause of Caliyah's death, Justice Ellington wrote. There was no evidence that Caliyah's death was a reasonably foreseeable consequence of Bell's drug use or drug use in the home by McNabb or others, or that it was reasonably feasible that McNabb would commit the horrific crimes that resulted in Caliyah's death. And there was no evidence presented that showed Bell was a party to McNabb's crimes, that she heard McNabb striking Caliyah and did nothing to stop him, or that she refused to provide Caliyah with potentially life-saving medical treatment. So basically, they were saying there is no evidence of any reasonable jury should have been able to convict her of any of these crimes. What I was reading, I'm like, what more do you want? She was convicted in May of 22, and this came, or May of 19, I'm sorry. And this came down in October of 23, which overturned her last charge that she had pending. So, yep. I don't know what more the prosecution could have done. The second degree one was a little hard for me because she did not participate in any of that, but she knew she had a home that was not great. She knew she had a home environment that was not good. And she brought the baby home, and she kept bringing the not good people home with them. So, yep, a few years. He's in for life. And, eventually maybe we'll end up where he said, underneath the, prison. But yep, at least she did some time. And whoever said that hopefully she can't have any more kids, I'm with all of you. I hope that she does not get Clarissa back. I think Clarissa's with her dad. At least that's what he said during that trial. I have no idea what happened after. So wherever she's at, I hope she's doing well. I hope she's not with her mother. I cannot find any information about where the mother is at. And yeah, I don't know. So I was shocked, absolutely shocked. Because one, it's really hard to get a jury verdict overturned on appeal, let alone one like this. And for them to keep saying that, they kept saying there was no evidence that a reasonable jury could have convicted her on. Like, okay. So I don't know. I don't know what you guys think. Well, I can kind of see what you guys think. It's not great. And like I said, I was shocked. So that's the end of that. And we're going to go to another great parent on Wednesday. Not only, Roseanne, does she have no judgment? She had no backbone. She couldn't even stand up and just speak for herself in front of the judge. She didn't even know how to do that. And there is a level of neglect there. I agree, Adair. Absolutely. And the judge, her attorney saying that she had no guidance. Okay, well, just because her dad raised her doesn't mean that she didn't have any guidance. And there are a lot of people out there, I know some of them, who had horrible, horrible childhoods. Who parents beat them, or things happened to them that, and they are great now. They didn't let them stop them. They're great. They're doing great. They're making good choices in life, and they're working really hard. So she could choose to, okay, I didn't have the greatest thing. What do I need to do? What do I need to fix? I don't know. I don't know anything about her dad. The prosecutor didn't seem to really have great things to say about him. She didn't really say anything about him. But it's a choice. She's an adult. Figure it out. In Hamilton, I don't know. It's hard to say. The judge, from what I was reading, the judge just had the trials together because the witnesses and all the evidence would have been very repetitive, and he thought it would just kind of be a waste of money, taxpayer money and time to have separate trials because everything was just going to be pretty much the same. So that's why they had them together. Thank you, Carmen. You're welcome. Are you just saying that so I'll pick you up at the airport tomorrow morning? And I'm sorry. I hate if you had, nobody had a perfect childhood, but there's a not perfect childhood, and then there is horrible childhoods. And I will not even pretend to know that end of it. Mine wasn't perfect, but it wasn't horrible. And so I'm sorry. And it sucks. But Gabrielle, you've got a great sense of humor. You keep us entertained all day. So, you know what? It seems like you're doing very well in life. She was definitely a crap parent. She did not participate in the unaliving. But did she create the environment that she should have known something was going to happen? Was basically the charges. Yeah. Lisa, I just, it's crazy. Absolutely crazy to me that it got overturned, that everything got overturned. Like I said, if you wanted to say something needed to be, I'll give you the first 2 charges that they overturned, fine, but not the last one. And that's probably very true. Gabrielle. Oh, see, you better be here all week. Well, Wednesday and Friday. Oh, my computer's doing stuff now that I didn't ask it to do. And we all do, Stormy. We all do. And you just look, I mean, I tell my kids all the time, I wish I would have done this better, or I wish this wouldn't have happened. And most of the time they're just like, sometimes I don't even know what I'm talking about, but it's something that bothers me that I know happened when they were younger. It's not like anything serious. I just wish I would have handled it differently. But other times they're like, but don't worry about it, Mom. It is what it is. Now they can say that, and I still do. So, yeah. All right, you guys. We will do my plan. You know how courts are. You never know. We will do Ada Montgomery, hopefully, Wednesday. And I'm obviously still start at 10:30 a.m. Eastern time, if you don't know that one. And that, hopefully, then we can kind of skip through the breaks. And, but I'm sure if they start Wednesday, we'll catch up to them being live at some point. So, and then, like I said, maybe we can take a break from bad parents doing horrible things. One thing we will not have in the Ada Montgomery trial is the medical examiner. Because, unfortunately, they have never found harmony. So, Gabrielle. Yes, regular time, 10:30 a.m. Eastern time. Yeah, I wonder what the jury thought about this thing, their whole verdict being overturned. If they know. I'm sure they do. It was on the news down there in that area. I can. I've been with you in that one, Stormy. Yeah, I hope we don't ever. I mean, unless she really gets some help, get some counseling. I hope she doesn't ever. I hope she doesn't have any more kids. And but hey, maybe she'll if she can get her like I was reading Carmen's comment, get her life together. Uh, I'm all about there's redemption for sometimes. My thing is I get in trouble with myself because I always want to believe the people are going to do the right thing, and I always want to believe the best in them, and I always want to believe that is in there and it within them. And then you just sometimes meet people and it's not. It's not there. Doing the right thing is not there. And sometimes it takes, I try not to think everybody's like that, but I also don't just blindly think, everybody's good anymore because I keep telling myself they're not. Uh, I I will I have some court documents that I found that I'll print out, but he says that he didn't do anything to her on Adam Montgomery. The mom didn't report her missing, I believe, for 2 years. So they don't know they just don't know what happened to her. He has maintained that even in his uh Gabrielle, we're just calling them pew pews now, case where he's already in prison for decades. Uh he proclaimed his innocence even then. My necklace all tied up. So, but just reading some of the papers on this, it's not good. It's like him and his wife, which would have been her stepmother, were living in a car with a couple of other children, and if she would have an accident, a restroom accident in the vehicle, he would supposedly punch her in the side of the head. And they're thinking that that's maybe what happened, but it went badly. And then he dismembered her, maybe. But they didn't know. 2 years is a long time, and I don't know why mom didn't report it sooner. So, uh, yeah. And then the wife, I she's in prison too. Is she in prison for part of this case? So I don't remember. I'll have to read the court documents because I think they were trying to get it so that his wife could not testify. And then her testimony that is in there, and I was only able to kind of skim it, but I don't think it was good. I don't know. I don't know if he is or not. Wouldn't surprise me. She did. Yeah. So, yep, doesn't take much to get people to turn on each other sometimes, right? Especially when they're great people to begin with. So, yeah, that's the plan. Um, only saw I was trying to look to see what the scheduling was, but I couldn't find it. I saw that the defense had 2 witnesses listed and the state had I had seen 55, I've seen 77. So, who knows if they're going to call um, all those people or not. But so I think we may have to pull off of this one to do like we did with Shonda. Tucker? We just stopped Tucker's trial, went and did the sentencing. So we may have to do that too to get Paul's sentencing. Yeah, I don't even care what they do with him anymore. If what y'all have said is true. I don't care. I don't care. I, the to those of you that didn't, if you didn't feel sorry for Paul, Darian, Shonda, you were right because I did, and now I feel gross about it. So I just really thought she had control of him, and I don't think so anymore. I don't think so. It's just a lot of grossness. A lot of grossness. Oh, good. Gabrielle, I went to Boston when I was in 8th grade with my parents. So I don't know if that's where, if I thought you said Boston, if that's where you were from, but this woman, so my dad had to go there on business. And at the time, we lived in Nebraska. And so the wife of the businessman asked my mom if there were buffalo still like roaming the plains out there that, I'm like, yeah, we have to dodge those Native American arrows all the time too. And we just got electricity last week with some indoor plumbing. Like, holy cow, are you serious right now? Have you never been out of the state? There's a whole world out there to the west, and it's civilized, I promise you. So yeah, that's my uh, yes. And then the guy says, tell me that he wanted me to say I parked my car in Harvard Yard, which I can't say it, but Gabrielle, I know you can say, you would say, I can't do it. I can't do it because I'll laugh. I couldn't even understand him. His Boston accent was so heavy. I'm like, I don't know what you're saying. I parked my car in Harvard Yard. So, yes, it was fun. That was I went to Vermont once, and they did not think I don't even think they thought Nebraska existed. So it was like they were surprised I had shoes on my feet and I knew how to tie my shoes or even write my name. But but that's my East Coast adventures. Not many, but it was interesting to say the least. Yeah. Car keys or cocky? Cocky, I can't even do it. Wait, a Yankee gringo. Wait, where did that go, Stormy? Oh, that's hilarious. Oh, well, you guys. All righty. Ka. Yeah, ka. So, Gabrielle, are you a Red Sox fan or Stormy? Are you guys are are we going to have issues in baseball season? Because I'm a Yankees fan. So don't unsubscribe. I am all tangled up here. Don't anybody unsubscribe just because I said that. You hate baseball. I used to not watch any sports. Good heavens. But my husband watched them all. And okay, good. You're at least I have Stormy. But my husband is down to just watching baseball. And I used to like the Mets. So we were literally like our mailbox was one side Mets, one side Yankees. But then the Mets started losing all the time. So I just like it's just easier to like the Yankees. I'm getting more and more twisted. So that's my that's what I like. And but I will tell you when the uh, and just if there's anybody in here other than my daughter that lives in Texas, please don't take this personally. But when the Red Sox played Houston, I was a Red Sox fan for that World series. Because Houston always has the Yankees number. All right, do you guys see this? I'm gonna choke myself between my necklace. All right, as my subscribers just continue to leave. Sorry to embarrass you, Carmen. Oh, good heavens. I'll give up. I'll do it later. I'm like- I might I might still be sitting here tomorrow morning, Carmen, when you get here. All right. So you guys may see Carmen Wednesday. She's got an appointment here, but if she gets done and we're still going, I know she'll come and pop in and come sit beside me. So I'm gonna go so I can. I might have to because I might just have to unplug it from my mic and just leave it hanging because I just have made things worse. I mean, good heavens. Yes, you will know. That'll be your clue if I'm not there. Also, she's gonna freeze. She's coming from Texas. So, and we're warm. It's like 55, 54 right now. So it's very warm. Not for her. Yes, studio appearance. All right, guys. I'm gonna go. See you guys Wednesday, 10:30 a.m. Eastern time. And we will go find us some more horrible parenting. So, y'all enjoy the rest of your day, and I will see you all Wednesday. Thanks for joining me today. I sure appreciate it.